my section 34 application, Mr. Sinha is, my lord, is on notice, my lord. But I will seek an adjournment. In all likelihood, I'll withdraw this application, my lord. This is that synergy matter, but I started my argument. But I might withdraw this, my lord. Kindly fix it a week hence or 15 days hence, my lord. I'll come.
Could his appearance to be mentioned, my lord, a week hence, my lord? If he withdraws, my lord, I have nothing to say, my lord.
Kindly,
Can I record this? Can I record your submission or only simply?
Don't record it today, my lord. But most likely, I'll come with an instructions in writing, my lord.
My lord, fortunately, now everything is recorded, whether your lordship records it or not. It's already recorded, but whether we like it or not.
Though the item number 15.
15.
15
Fixed at 12:30 minute.
Though the matter is specially fixed today as 12:30 PM for hearing, but the learned counsel for the petitioner prays for adjournment. Accordingly, case adjourned. Let the matter appear on 18th.
18th as to be mentioned, Lord.
August 2025 as to be mentioned.
Very well.
I'm grateful. Lord, may I inform the bar, my lord, about, otherwise, no, they'll be
deeply obliged.
Yes.
My lord, kindly to mention, my lord, this is the Purti matter in which your lordship on 5th. Purti matter, my lord, which we on 5th your lordship had directed us to file an application for subpoena, my lord. My lord, the matter was kept on 11th, on Monday. My lord, we have filed the application, my lord, but the order has not been uploaded. The 5th August order has not been uploaded. So, my lord,
not uploaded.
No, my lord, I have checked it personally yesterday. So, my lord, may the application appear on 11th on Monday along with the suit, my lord.
Let it come. So what do you want?
My lord, the application should be tagged with the suit, your lordship. Otherwise,
You filed the application?
yes, your lordship, the application is filed.
It will come. It will come.
I'm so grateful.
Yes.
I was praying for your lordship's leave to mention, my lord, the Pradyumna Sinha matter. Your lordship had directed to appear, my lord, at the top of the list on 24th July. It could not be taken up, my lord. This is your lordship's last order.
Yes.
I'm mentioning on notice, but I don't know when your lordship.
On the other side.
For the interview. Nothing much to say.
Mr. Anirban Rai was appearing for the other side.
इसको कल to be mentioned में कर दो. Tomorrow let it be to be mentioned.
Very well.
Lord, with your lordship's kind leave to mention a matter.
On Monday,
Monday.
Look, with your lordship's kind leave, I'm mentioning a matter, my lord. Your lordship was pleased to fix the matter for witness action on Monday the 11th, my lord. In the meantime, my lord, the witness has fallen down, broken his bone, my lord. And if your lordship, my lord, kindly, my lord, is not in a position to come before your lordship.
It is very unfortunate of this court. Whenever this court is fixing the matter for the witness action, either witness fallen down or the advocates fallen down or the companies winding up or anything is good. So henceforth, I will not fix the case for the witness action. Otherwise, you are unlucky.
My lord,
for fixing the matter
lord,
for the witness action.
My lord, I'm carrying, my lord, the...
I will bring so many documents for falling down, fracture, hypertension, sugar. I will bring, you want, I will give the document to you, sir. I was there for over 25, 27 years. How the adjournment is to be taken from the court, I know all the track.
My lord, the witness...
Because 2 days before one matter was fixed, his client is admitted. Prior to that, and one matter was fixed, client was suffering from high fever. Now your client has fell down and got fracture.
My lord, and also other complications are there, my lord.
I will make a more complication. Let you pay the cost.
My lord, I leave it to your lordships, my lord. It is fixed on 11th, my lord.
11th of
this month, my
Monday.
Lord. Monday, my lord.
At 11:30.
My lord, it is fixed at, my lord, 3 p.m., my lord.
So note karo. Okay, come on that division. Yes, next.
Thank you, your lordship. I am mentioning upon notice that it's an extremely urgent.
My lord, Mr. Chaudhary is appearing online.
We have no objection. I believe they are mentioning for upgradation. We have no objection.
Lordship, the suit was presented before my lord on 1st of August, lordship. We had already prepared an application. They were on caveat. We have already served them. Lordship, it is appearing as item number 26, lordship. There is some urgency if it could be taken up, lordship.
Who is
Sir,
for
My
I
lord,
would hope my learned friend has served, my lord, the respondent number 2.
Hmm.
Because, my lord, I am appearing for respondent number 1 who was on caveat.
Hmm.
The transferee, I hope, has been served. Lord, we have no objection whenever your lordship wants.
Someone is not on caveat. I'm
No, who
moving
is on
the other-
caveat?
my lord,
They
we
have
are on
already been
caveat on
served. I
behalf
do
of
not know
respondent
why this
number 1 only.
apprehension, my lord.
Mr. Chaudhary is appearing, my lord, on
Yes.
behalf of respondent number
Let him
1.
speak for himself, my
Have you
lord.
served
the
the
client.
copy?
Yes,
served the-
already, my lord.
वो उसको वो 3 बजे है ना
My lord, not today, my lord. Mr. Chaudhary is not there.
No, no, I-
my lord.
11th at 3
If I'm led by,
I'm
Mr.
led by Mr. Mitro. So if Mr. Mitro is there, it's fine, my lord. There is, if they want to move it, my lord, we can't stand
Moving
in
to
the way.
next week, my lord.
Not today. I am fixing on 11th at 3 p.m.
11th, great.
11th at 3 p.m.
Mr.
Yes,
Chaudhary, you're not in
Yes,
town.
yes, yeah, and please serve the respondent number 2, otherwise it could be
Lordship,
meaningless.
the apprehension of the respondent number 1, whether I have served upon the respondent number 2 or not.
I will see to that.
My lord, on 11th at 3 p.m.
11th at
Are they really serious?
item number. Item number. Yes.
My lord, may I have your lordship's leave to mention the matter? My lord, this is the revocation of patent which your lordship was hearing.
Ah.
My lord, the matter was fixed on the 4th of August at 12:45.
Hmm.
My lord,
12:45.
yes, 12:30. I'm sorry, my lord. 12:30. It was fixed on the 4th of August.
Hmm.
If your lordship kindly fixes it, it's running in the list, my lord. Item number 199.
Hmm.
If your lordship kindly considers fixing it, because my lord, the submissions are going on. Any as your
September.
as your lordship.
Lordship, may I be permitted
Item number. Item number.
199, my lord.
199. Record an order. Who is for the other side?
My lord, I have served notice, my lord. I will inform the other side if your lord.
Counsel for the plaintiff.
Not plaintiff, my lord.
Appellant. Appellant or applicant?
Petitioner.
Appeal.
No, this is a revocation
Revocation.
application.
Counsel for the petitioner has mentioned the matter on the though the matter is listed in the days list as item number 199.
190.
199.
My lord, my learned friend is for the respondent.
But the learned counsel for the petitioner submit that this court submit that the matter was fixed on 4th of August
Yes.
2025 at 12:30 noon and 12:30 p.m. But due to non-availability of the court, due to non-availability of this court, the matter could not be taken of hearing, and the press for fixing the matter on a specific date and time. In view of the submission made by the counsel for the petitioner, let the matter appear on 23rd September at 3 p.m.
23rd.
May I be permitted to mention
I'm
on
ready.
matter, your lordship?
Yes.
Your lordship, this order has been passed by your lordship, wherein your lordship directed plaintiff number 2 to take inspection
Ah.
of the original documents.
Hmm.
Your lordship, this application was filed by the mother of the plaintiff number 1, who is the power of attorney holder. Now the original side registrar, the office of the original site registrar is not giving the inspection, as direction is upon the plaintiff number 2, who is staying outside in Bangalore for his job. Your lordship, kindly direct that mother be given the inspection and time be extended.
Plaintiff number 2 is at liberty to inspect the document before the registrar original side. Yes.
Lordship, plaintiff number 2 is staying outside in Bangalore.
It was the application of the plaintiff number 2 itself.
Your
He only
lordship,
wanted this.
mother, mother of the plaintiff number 2.
How? She is not a party.
But your lordship, she is the power of attorney holder.
Where is the power of attorney?
Your lordship, that is not now presently with me.
To report about the filing of the power of attorney on behalf in direction the understand submitted particularly. क्या मतलब क्या है? मतलब क्या? हाँ, तो ये क्या है? हाँ. भेज दिया ना, ठीक है. Now you go to it. Power of attorney has
Your
just
Lordship, time be extended because time was till today.
yeah, the matter is mentioned by the learned advocate appearing for the
Plaintiff number 2.
is a contempt application
Yeah, petitioner.
for the applicant number 2.
Yes, Your Lordship.
Applicant number 2 and submit that by an order dated 1st August 2025, this court has allowed the plaintiff number 2 to inspect the document before the registrar original side within a week from date. We submit that the plaintiff number 2 is not in position to appear in person to inspect the document. Unless the plaintiff number 2 has executed a power of attorney in favor of her mother. Her mother.
Yes, Your Lordship.
Her mother. Police. In view of the above, the registrar is requested, is directed to allow the mother of the plaintiff number 2 to inspect the document as allowed by this court by an order dated 1st August 2025 within a week from date.
Grateful, Your Lord.
Yes, next. GA Com 3 of 2025 is dismissed.
Grateful, Your Lordships. Lordships, a short, small request. Your Lordships, DA2 may be fixed on Tuesday for your hearing, Your Lordships. A short application, Your Lordships.
It's not a short application.
On law, Your Lordship. Your Lordship, led by Mr. Thakkar, he is appearing.
My Lord, I appear for the plaintiff in this matter. My Lord, I have GA1, which is an application for interim reliefs. My Lord, to delay all these other two applications have been filed. GA1 is not being taken up because of the Section 8 and the 12 revocation. Kindly fix the Section 8 for hearing anytime Your Lordship's diary permits, my Lord, anytime your board permits.
Problem is the date.
Today, my Lord, 12:30 matter got cancelled, my Lord. I can come even at 12:30.
The other side will not be available.
It's not possible. I have a leader, Mr. Banerjee. I have to.
Today, other side will not be
His
because their
availability also.
application. Otherwise, this court can take the matter.
I know, man, but kindly fix a date. Any date Your Lordship deems. Otherwise, the GA1 is becoming delayed, man. That is the only fear.
Okay, let the matter come. Though the application being GA Com 3 of 2025 is dismissed, accordingly, counsel for the plaintiff submitted the plaintiff has filed an application for grant of interim order being GA1 of 2025 and the defendant number 2 defendant has filed an application under section 8 of the Arbitration and Cancellation Act being GA2 of 2025 being for referring the parties to the arbitration. Let put the application be placed before this court on 12th August under the heading new.
Grateful, my Lord, deeply obliged.
Yes.
Well, this matter is appearing at my instance. Well, if your Lordship recollects, well, I had mentioned the matter on behalf of the defendant number 6 and 7.
Yes.
Well, I had respectfully besieged upon your Lordship, hearing so far as the defendant number 6 and 7 is concerned was concluded. We had also filed our notes, Mr. Thakkar had submitted on behalf of the plaintiff. So that part is over. And
Yes.
we had filed the note, as long back as in 2nd of May 2025. So
Yes.
Thereafter, other defendants are being heard. So I was respectfully submitting, since my matter was being heard pursuant to order of the appeal court, and your Lordship had concluded the hearing, notes filed. So if judgment could be delivered.
Further, who want to argue the matter further?
The defendant numbers 11 and 12 had filed a vacating application. They didn't file an affidavit. So they used a vacating. They took time on the last day to file a reply because I filed an opposition.
You file the application. Let it come on subsequent date. Yes, another. You have 10 and 11. 11 and 12. And what about the others?
My Lord, 1, 2, 3, 4, 5, 6, my Lord, 1, 2, 3, 4, 5 have also filed a section 4, but that is on their section 4. That is not here, not there.
Yeah. Now, with regard to the
there are two vacating applications. I think 8 and 9 has also.
Yes.
Well, none of the none of the other defendants are serious in pursuing their applications or in addressing. So since our application, so far as I mean, our submission in respect of these 6 and 7 was complete. I was respectfully submitting notes filed, everything done.
Because there is an appellate order, the other defendants are one or the
Correct,
other.
correct,
They
correct.
are filing south. This court can proceed with the matter because there is a direction of the appellate court for regarding the 6 and 7. And 6 and
Correct. Well,
7, what can be done?
Kindly dispose of so far as 6, 7 is concerned.
And dispose of the 6 with regard
My
to 6 and 7. What can be done?
my
One or the other defendants are coming one on another application.
my.
I think 19th is the last hearing, Malad. 19th is fixed for.
Our arguments and we have also submitted the written notes of argument.
Which matter?
Defendant number 11 and 12.
So why you file an application for vacating?
Well, defendant number 11 and 12 has not filed.
Yes, just you submitted. Just you submitted, file an application for vacating.
My lord, it has been filed by defendant number 13 and 14 and 8 and 9, my lord.
See, 11 and 12.
We have not been
My lord,
Just yes.
we have not been served with.
That is the problem. Okay.
I was.
My lord, kindly, deeply, my lord, just kindly consider our prayer. Hearing concluded, notes filed.
Let Mr. Bose, let the matter come on 20th. I will see if anybody is coming for argument. Otherwise, I will fix the matter for orders in regard to the your application.
Malad, it can be fixed for order by everybody, Malad. Hearing can be concluded.
Yes. Let the though the matter is fixed on 20th August 2025, but the matter is listed as to be mentioned on the prayer made by the counsel for the defendant number 6 and 7. Counsel for the defendant number 6 and 7 submit that with regard to the submissions of the defendant number 7, hearing it with regard to the contentions of the defendant number 6 and 7, hearing has been completed and place for passing appropriate order with regard to vacating, with regard to the interim order passed against the defendant number 6 and 7. This court that there are several defendants and have filed several applications. Let the matter appear on 20th August 2025. It is made clear that on the date fixed, if the other defendants fail to move their application, the application, the contentions of the defendant number 6 and 7 will be taken into consideration, will pass appropriate order only with regard to the 6 and 7.
Grateful. Good.
Yes.
Lordship, I'm for defendant number 1, Lordship. I'm praying for not today.
Why? Why to be mentioned?
No, I appear, but there is sole plaintiff and sole defendant.
Defendant, my lord.
There is no defendant.
You are appearing for?
Defendant number 1.
There is no defendant number 1, my lord. Sole plaintiff and sole defendant.
Must be some other number. Must be some other matter.
And
The
defendant
cost
number?
title is.
Yes. Yes.
Who told you to?
Who is your?
Mr. is appearing.
No,
Mr.
no. There's
No.
some other matter.
Yes.
My lord, I am the defendant. My lord, suit for recovery of money which was decreed on a judgment upon admission application. My lord, they applied for execution. Now, my lord, in the execution proceeding, my lord, the parties resolved their disputes. My lord, this is the order. There was a settlement agreement and the agreement has been given effect to. And the order, my lord, records that the decree stands satisfied.
Yes.
Yes, my lord, I had a counterclaim in this suit. I do not wish to proceed any further. Lordship can, my lord, dispose of the suit.
That as well.
Have you got the written instruction with regard to the contract?
No, my lord, I do not have written. Yes, I have written instructions. Yes.
I thought you were asking for written statement.
Written instruction. But may I have your lordship's leave, my lord?
The matter is listed as to be mentioned on the prayer made by the counsel for the parties. It is submitted that initially this court has passed a decree upon judgment. Decree upon judgment. Full stop. The plaintiff had preferred an execution proceeding for execution of the decree passed by this court, being execution case number
My lord, EC 324
EC
of 2019.
of 2019. Full stop. During the pendency of the said execution case, parties have settled their disputes by entering into the terms of settlement. And accordingly, the learned court dealing with the execution proceeding has disposed of the execution proceeding by an order dated 2nd December 2024.
My lord, the terms of settlement are dated 29th of November,
Yes,
2024.
क्या बोला ऊपर पढ़ो
Case number E324/19 during the pendency of the state execution case, parties have settled their disputes by entering into the terms of
settlement dated 29th of November 2024 and
according to the execution proceeding by
January 20. Full stop. Now the party submit that full counsel for the defendants and plaintiff submit that the defendant have filed the counterclaim, but in view of the settlement arrived within the parties, the defendant is also not interested to proceed with the counterclaim filed by the defendant. Full stop. Both the learned counsel appearing for the parties praise for passing of paying for disposal of CS number
24, my lord.
CS number CS COM 94 of
CS COM
2024 within bracket old CS number 24 of 2020. In view of the submission made by the counsel for the parties that the parties have settled their dispute by entering into the terms of settlement dated 29th November 2024. On the basis of which the execution proceeding is also disposed of. Accordingly, CS COM 1994 94 of 2024 within bracket old CS number 77 along with the counterclaim is disposed of.
Grateful, ma'am.
Or not, I am the defendant, my lord. The office report relates to a technical mistake, my lord.
Yes.
What happened that Miss Neha
Along with the
Datta,
affidavit competency, Sanjay Ganodi submitted an advocate intendant to have been opted no objection. No advocate has entered reference. Yes.
my lord, Miss Neha Datta, she is the advocate on record. Now
Now.
what? Yes, at present also.
Ah.
Now what happens that during the process, my lord, there is a change in the, in the advocate on record, but
Of the
which has not
defendant.
of the defendant, my lord. Now, which cannot be exactly affected because previously there was Fox and Mondal and thereafter.
No, but the Fox and Mondal, I saw the report.
No, yes, because they didn't file any. Now Ginodia has come up. Now she will file no objection. I mean, one wakalatnama endorsing no objection from her, my lord, and accordingly it would be corrected, my lord. Please give us a leave to ensure the correction in the wakalatnama, my lord.
For what correction? What correction you need?
My lord, because what we have done that is not correct. So now that we have to file another wakalatnama by taking no objection from her, and Ginodia will file.
Objection from whom?
She is the advocate on record, Sneha Datta.
Of which company?
Defendant, United India.
Defendant.
Yes, now
Of
there
the Fox
will.
and Mondal.
No.
Ah.
Fox and Mondal never appeared.
Never appeared.
Now Ginodia will appear, my lord.
Correct.
Yes, that would be done by Monday, my lord.
Correct. So what we want the no objection from how? Have you filed the wakalatnama?
Yes.
No, there is no report.
No, she is Sneha Datta. She has filed. She is on record. Kindly see.
Where is your Wakalatnama?
My lord, this has been filed on 2nd December 24, my lord. This
What
is
is your
from
name?
Sneha Dutt.
Wakalatnama कहाँ है? Where is the Wakalatnama name? Department? वो तो डाला है ना, वो क्या है? वकालतनामा भेजा है, वो तो वही नहीं उसका तो because the report says something else, the none appears on behalf of the defendant.
No, Sneha Dutt has filed.
No, kindly see the report.
It is there, my lord. There it is written in the order sheet of the court also.
Might be. That's why you are telling here something here you are not doing in the department. That's why in every case the court has to call for the report. You persons are submitting something else before this court and you are doing something else in the department.
Lord, it is there in the
there is nothing.
Sneha Dutt's name is appearing, my lord.
May be appearing.
No,
you might be mentioned before the court. It might
is
be
that-
appearing. Show me the Wakalatnama. It is a report. I call for the report from the department. Department says no Wakalatnama.
In the case status also it has been.
My lord, let me see it, my lord, once. I need to see. Yes. Please
Not-
give us some
As per
time.
the prayer made by the counsel for the defendant, you are for the defendant.
I'm the fourth, only
Defendant, the
sole
case at
defendant.
John. Let the matter appear when?
Next
14th?
week, my lord, any day.
14th?
14th, yes.
14th has to be mentioned. Next. Check the department's file.
I appear for the plaintiff, my lord.
Yes.
My lord, in item number 7, I was appointed as the commissioner, my lord.
Ah.
The report is ready, my lord. May I be file my report, my lord?
Just five. What is the 5?
5 CS number 2. 180. No, 180, my lord. The commission is still going, my lord. I
Why is
believe they are to
180?
close in some time.
Who is the commission in the 5?
Mrs. Shananda Mukhopadhyay. Miss Shananda Mukhopadhyay. So, my lord,
The difficulty is that only one witness is giving evidence for all 4 suits. That is why, my lord, we could complete 1 suit totally. The other 3 are pending because the
Which are pending? 180?
180
except 182, my lord, everything happened.
180, 181.
Yes.
And 183.
And 183.
They are the pending.
Yes.
And 182 is
182 has been completed.
The witness recording of witness of the first witness of the plaintiff is done. I don't know whether they are going to bring a second witness.
My lord, we are going to bring, my lord, but we are not going to give in evidence in through commission. We will take instructions regarding our second witness, my lord, but
In that event, your lordship will not discharge the
correct. That is the problem. If you want to
commissioner.
examine the witness, let it,
It
continue
cannot
in
be
the
done
commission.
in the
commissioner, first witness has completed his
Correct.
evidence. First witness may be discharged so far as, my lord, the commissioner is
Witness will
concerned.
be discharged with regard.
So far as the commissioner is
So
concerned,
you have to submit whether
the
you
lordship may kindly keeps the matter on Monday, my lord. We will take in
why it is come today.
for filing of the
So
report.
that's why. So you have to. You are not any idea with regard to whether you will adduce any further evidence or not.
Then we will do it.
How you are conducting the case?
How do you say?
You are not aware of whether you will adduce the further evidence or not.
Lord, we have to just take confirmation from our senior, my lord. We have
When the chief was concluded.
31st. No, not 31st.
My lord, the last question was done on 25th, my lord.
25th of July.
July.
Yeah. 15 days is passed. You have not taken any steps whether you will examine the witness or not.
We have taken instructions. Only it's for confirmation by our senior.
Whether you will examine the witness.
Yes, my lord. There is a second witness,
the
but we will not do it in commission, my lord. The
Why?
reason
Why
being, my lord,
part commission, part
the
before?
reason being, my lord, it's. I think it's better if Mr.
The order passed on 1st of February 2024 appointing the commissioners read as
1st of
Such and
February.
such appointed as commissioner to record the evidence of the witness oblique witnesses of the plaintiff. That
1st of February.
first
The
of
order of appointment of commissioner, my lord.
evidence of witness, my lord, page 2, last line.
Dated.
1st February
24.
2024.
Second witness is second witness. Hello. Second witness.
My lord, may I hand over a copy?
Yes, it is there. Plaintiff informed about the London Commission report.
Commission ही करता है. Commission ही करता है. Order records. Plaintiff witness.
4 months for under short extension.
Second page, last line.
By consent of the party, so and so for evidence of the witness of the witnesses of the plaintiff, as the case may be. Yes.
Let second witness, my lord, we'll do
We'll
it in
examine.
commission. Yes. We'll examine. There is nothing. Your lordship may kindly extend, my lord, all the matters for.
My lord, may I file my report for the
I will
first-
take. Just with regard to the other, let me extend the time. CS number 307 of 2024 within bracket old CS 180 of 2021. Then CS com 308 of 2024 old CS 181 of 2021. And CS number 183 CS com 310 of 2024 within bracket old CS 183 of 2021. Counsel for the party submits that. Is still the examination of the plaintiff. Examination chief.
No, cross.
Is still the examination, cross examination of the plaintiff witness number 1 is going on before the commissioner. Accordingly, the place for extension of time to file report by the commissioner. In view of the submission made by the counsel for the parties, time to file report by the commissioner is extended. How much time it will take?
Not that much time is required because these three are at the verge of completion.
Correct. How much?
So, my lord, they should not. 4 months can
Here, my lord, the difficulty is we can do it day to day, but the witness is not available on each of the days. Your lord.
No. That is, I am.
Is extended.
Day to
day. 12th of November 2020.
12th of
November 2020.
12th November.
First of
Your lordship, CS.
December, my lord.
Lord, just to my lord, interject. CS 307, that is the first matter. Subject to correction, my lord, they will be requiring only 1 or 2 days.
Okay, if it is
before the commissioner,
mention the matter.
Very well, my lord.
Extended till the month of
Lord,
December.
just a word of line, Lord, that in the meantime it may
If
be
it is completed, let him mention. I will take the report.
That is needless to say, my lord. Once it is completed, the commissioner will come and
automatically
we have
file
to
the
take
report.
steps.
Till 28th of September, November 2025. Let the matter appear on 28th of November 2025 for filing
My lord,
report.
may I humbly beseech, my lord, the intervening pujas and the
November intervening puja is
first week of let it be extended till December. Unnecessary.
Lord, we are agreeable for
Again
day
to
to day.
December, then the
We are
Christmas
agreeable for
vacation will
day-to-day hearing,
Let's
my lord.
come on
We want to
28th
complete
November. Let me see what progress. The commissioner is a liberty. In the meantime, the commissioner complete the examination of the plaintiff witness, he has liberty to mention the matter to file the report before this court. Okay. Now CS number
309.
309 and CS com 309 of 2024 within bracket old CS number 182 of 2021. Learned Commissioner is present and submit that and filed report after serving a copy to the Learned Counsel for the parties. Let the same be cut to the report. Counsel for the plaintiff submit that the plaintiff will adduce furthermore witness accordingly. Let it be continue.
Yes.
Let the commissioner continue. Let continue to examine the plaintiff witness number 2 on commission and to file the report on 28th of November 2025.
I believe in this matter further time will be required because I have to file my affidavit and evidence.
28 come on that day.
Very well.
If it is not, then.
Very well.
Item number 9. I am for the defendant petitioner. I appear for the, my application for amendment was hearing concluded. Matter was fixed for filing additional notes. I have no, my lord, only a short clarification we have given in respect of the documents and nothing else, my lord.
Counsel for the defendant filed supplementary notes of argument after serving the copy to the land counsel for the plaintiff. Let the same be kept with the record. CAB.
Lord, I'm much obliged.
Lordship, I am for the plaintiff, Lordship.
Yes.
Lordship, in this matter, on 31st July 2025, one wrong submission has been done. That is that the scrutiny of the suit has been done. And for that, Lordship, uh, I am seeking your apology, Lordship. Lordship, kindly.
When you made the submission?
Sir, Lordship, on 31st July 2025.
So what is the situation?
Lordship, now what is the situation is that the presentation of plaint has not been completed and the scrutiny has not been done.
Presentation has not been completed.
Lordship, at first the presentation has made before the learned master, and he has sent the record to the Lordship as for seeking the leave under section 12.
Please for leave and go to go.
Now, Lordship, the
Yes. Then this court is allowed on 12th June to add the prayer.
Lordship. Thereafter,
presentation was made.
no, Lordship.
Record and all. So what you want now?
Lordship, kindly. Lordship, kindly fix this matter for presentation and plaint, and thereafter.
It is listed as to be mentioned on the prayer made by the counsel for the plaintiff. Counsel for the plaintiff submit that on 31st of July 2025, she has inadvertently made an incorrect submission before this court that this scrutiny has been completed and pressed for leave for lodging writ of summons. But the print has not been presented and is not admitted. Accordingly, she pressed for recalling of the order dated 31st of July 2025 and fixing the matter for presentation of the print. In view of full stop. Consider the submission made by the counsel for the plaintiff.
Lordship, one more instances. Kindly fix a date for that.
Here the submission made by the counsel for the plaintiff peruse the orders passed by this court dated. Peruse the order passed by this court dated 12th June 2025 and 31st of July 2025. This court find that after receipt of the print, the London master, senior master and official referee has submitted the report intimating this court that some of the defendants are outside the jurisdiction of this court, but the plaintiff has not prayed for leave under clause 12 of the latest patent 1865. On receipt of the report, the matter was placed in the list of this court on 12th June 2025. As per the prayer made by the counsel for the plaintiff, leave is granted to the plaintiff to add the prayer for leave under clause 12 of the latest patent. In view of the order passed by the as per the leave granted by this court dated 12th June 2025, the plaintiff has added the prayer for grant of leave under clause 12 of the latest patent in the prayer portion as well as in the concise statement. But inadvertently on 31st of July 2025, it was submitted before this court that the scrutiny has been completed and raised for leave for lodging the writ of sum. Considering the above, this court find that the plaintiff has made submission inadvertently without going through the record. Accordingly, the order dated 31st of July 2025 is recalled. Full stop. Let the matter appear. When? Tomorrow?
Lordship, tomorrow.
Let
is
the matter
that-
appear on 12th of August 2025 under the heading presentation.
Lordship, when the date has fixed?
12th.
12th. Lordship.
Come ready on that day.
But we appear on behalf of the respondent number 1.
I appear for the
Reading of the written notice of argument.
I appear on behalf of the plaintiff, but I am also filing my written note. But your lordship, in my written note, I have indicated that in what way Section 8 cannot be attracted. And also, my lord, even if your lordship is not with me on that, there are no arbitrable disputes subsisting under that agreement, which can be referred to arbitration because everything has been paid off under that agreement. So subsequent dues which they are claiming also are not in terms of that agreement. I have also mentioned that with relevant page numbers.
Okay. Counsel for the plaintiff and the counsel for the respondent number 1, defendant number 1, have filed their written notes of argument. Let the same be kept with the record. CAB.
I'm great.
My lord, item number 12, my lord, I'm appearing, my lord, for the plaintiff. My lord, permits me to appear virtually today. My lord, this is for presentation of plaint.
Yes.
12A, my lord, 12A already has been complied with. There's a non-starter report. The plaintiff is within jurisdiction. And my lord, the defendant is outside jurisdiction. Is a price of goods sold and delivered. Case of where, my lord, the agreement para 4 has been entered within jurisdiction. Invoices raised from within jurisdiction. Para 6, part payments received within jurisdiction. And my lord, they have also, there's a mail accepting liability. There's a para 12 that has been received within jurisdiction. Notices issued from within jurisdiction, my lord. And my lord, as a debtor, they are to, my lord, satisfy the creditor, my lord, that is within jurisdiction. My lord, I'm praying for.
When the last payment was made?
My lord, the last payment was received in 2023, my lord. 2023, 2024.
Okay.
And we have paid full court fees, my lord. And my lord, the cause of action we are pleading is at para 26. The limitation pleading is at para 26. And how is it a commercial suit? Pleading is at para 28 onwards, my lord.
With Mr. Bhattacharya's leave, the last payment was made on 18 July 24, my lord.
I stand corrected. 2024, my lord. I stand corrected.
July 24.
Yes, my lord.
The plaintiff has filed the present suit, praying for a decree for a sum of rupees 20,22,010 along with interest at the rate of 12% per annum. The plaintiff has complied with the provisions of Section 12, capital A of the Commercial Court Act by initiation pre-institution mediation process, but no settlement was arrived between the parties and non-restorative report has been filed. Full stop. Counsel for the plaintiff submit that the plaintiff is within the jurisdiction of this court and the defendant is outside the jurisdiction of this court. He further submit that part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of the court. Accordingly, he prays for leave under clause 12 of the latest patent 1865. Had the learned counsel for the plaintiff produced the materials on record and the pleadings This court find that part cause of action arose within the jurisdiction of the plaintiff is within the jurisdiction of this court, comma, defendant is outside the jurisdiction of this court, and part cause of action arose within and part cause of action arose outside the jurisdiction of this court. Accordingly, leave under clause 12 of the latest patent 1865 is granted. Plaint is admitted, subject to scrutiny.
I'm grateful, my lord. Deeply obliged.
Grateful, my lord.
This is my plaint for presentation, my lord. Commercial dispute is there, my lord. Goods sold and delivered. My lord, cause of action is within the jurisdiction, my lord. Defendant's office is within the jurisdiction of this honorable court. My lord,
why 12A?
my lord, 12A, my lord, because transactions began in November 2023, my lord. I have been selling goods and also providing services. Thereafter, my lord, till January 2025, there was no real dispute. December 24-25, there was no real dispute until the management changed. Thereafter, my lord, payments have been stopped. I have sent several emails. They have only responded in 1 or 2 emails saying that they are going through the records to check whether work orders are in place. I have annexed all my work orders, purchase orders, invoices. Also, my lord, invoices, work orders obtained from their website to show that work orders are there. Invoices to show they have received, and my lord, my ledger to show that payment has been lastly given to me as on May 2025 as well. Now, my lord, 12A, because this company went under amalgamation and they have given me notice of amalgamation on 3rd of June 2025. Before I could take steps, my lord, before the NCLT, I even wrote an email to them. The amalgamation order was passed on 10th June 25. Thereafter, my lord, I have written them emails on 12th June as well. They have not responded. Finally, my lord, on 6th of May, 6th of June, my lord, they have responded to me saying that they are willing to pay, but however, they are willing to deduct some sums. My lord, therefore, they have not paid any payment after that. I'm apprehending, my lord, that they are not going to, and we have also come to learn, my lord, that audits of the new company is being undertaken, whereby, my lord, claims are being extinguished. And as a stakeholder and as a creditor, they have not notified me of any of these steps. I've come to learn that from the other sources in the market. But
So
my pleading...
Who was the main defendant?
My lord,
Sakambari?
Shakambari Ispat is the new name. The defendant continues to be the same, SD Aluminium. And my lord, the order of amalgamation is at page 16. And my lord, if lordship comes to page 41 of my application, my lord, lordship will see the nature of amalgamation.
Page 16.
My lord, 16 is the order, my lord. At page 41 is the recording of what are the liabilities that have been transferred to the current defendant.
Yes.
At page 41, lordship sees all properties, rights and interest of Shakambari Ispat, which has already been amalgamated with, includes Bravo Sponge, will be transferred to and vested and without further act or deed in SD. SD is the person with whom I had my original transactions with since November 23. And my lord, lordship will see the name change is also there at page 43. Clause M, that the name of SD Aluminium shall stand changed to Shakambari Ispat. So, my lord, SD's liabilities have not gone. The name has been changed and 2 other companies have come in. And, my lord, I have made my pleading for 12A, my lord, at para 20 of my plaint.
Para 20?
Yes, my lord, para 20 of my plaint.
Yes.
My lord, they are undergoing a fresh auditing. And my lord, the fact that they have not notified me about the amalgamation despite series of emails that I have written to them for payment, my lord, I'm apprehending that they will extinguish my claims.
No, madam.
And lordship kindly sees the last email from their last communication, my lord, at page 656. My lord, it is a WhatsApp communication which they have sent to me saying that the management has they are negotiating, my lord, but they are not making any payment. Despite the fact that everything is on record. It is an admitted position that they will have to make my payment. Page 656, my lord, is that volume 5 of... Yes, my lord, volume 5. Let kindly see.
That's all okay, but how where is the 12A, where is the case made out for the urgent relief?
My lord, now I know that they are disposing of their assets and also changing their management. My lord,
the commercials.
Yes, my lord.
You have mentioned in paragraph 20.
Yes, my lord.
But you have not disclosed any audit.
My lord, I have done so in my application, my lord.
No, you can't.
My lord,
unless and until you disclose the document in the plaint, you cannot disclose the document in the application.
my lord, may I say, my lord, I am going by, my lord, the ratio in Dhanbad fuels, my lord, that if my plaint is simply contemplating the scope of an urgent relief, my lord can consider.
That's why, where is the urgency? What is the urgency?
My urgency is, my lord, that their conduct since January 25, that they have been suppressing these facts of amalgamation and transfer of liabilities.
That's why, where is the transfer of
My
liability?
lord, my lord, kindly comes to para 9 and my lord.
Amalgamation has come, amalgamation has come with the total interest it has come. You can
Yes, my lord, kindly takes up my email, my lord, kindly sees at page my lord, 652 is their email saying that it will be transferred, and on the very next page, my lord, 653, my lord, 4th of June. On 3rd of June, my lord, they write to me saying that
correct. This orders the admission.
and my lord,
It is a
they
question
have
for order 12 rules.
my lord, if my lord, may I say, my lord, if I had the opportunity to go through the scheme prior to the approval by the NCLT, if they had given me enough notice, I could have, my lord, had an option to secure my claim even while the scheme was being approved.
Correct.
They have not given me that time by sending me a notice on 3rd June. Before I could take steps, on 10th June, it has been amalgamated.
Correct.
And my lord, on 12th June, when I write to them again, that my lord, kindly see that page 655.
Yes.
On 12th June, I write to them again that an our request for a written assurance on the payment of the timeline. This was 71 lakhs, including TDS. There is no reply to this email. They, on repeated occasions, they have not responded. They have not given me any assurance that my payment can be secured in the scheme. And my lord, the most difficult part is till December 2024, when the erstwhile management was there was no difficulty. If lordship sees my ledger, my lord, I shall go through the. I
No,
shall
that's
take.
correct, madam.
The payments are coming. It's a running and continuous account.
Correct.
It is only after the management changes, my lord, that they have stopped.
The management changes. The new management cannot say you are not. They are not liable.
Yes, my lord, despite these steps taken by me,
You file the suit only for the Shakambari, not for the other new company.
my lord, the new company is on. It's the same, my lord. SD has just been renamed to Shakambari.
Okay.
There is SD Aluminium does not exist as a name on ROC any longer. So, my lord, I have no means of. It's the same entity.
If you want, I will pass a order if you want to take back and go for the mediation. Otherwise, I will dispose of on merit. I am not satisfied with regard to the paragraph 20.
May I then come back if I get any other documents?
What document? You file the suit, then no document. You can.
I have annexed everything in my injunction application.
That cannot be. How you can annex the new document in the injunction application, which is not disclosed in the plaint?
Not new documents, but my lord, I do not.
Which you are not relying in the plaint. How you can rely in the injunction application? They are commercial suit.
I understand, my lord. I cannot do that. But my lord, in view of the fact that they have not responded to my emails, there may not be a scope of any further mediation now.
Good case for the other proceedings, not for the 12A.
It's a very clear case of goods sold and delivered, lordship.
That's I'm telling. Good case for the other proceedings, but not for the 12A.
But my lord, they will extinguish my claims.
Nothing. What will happen?
And despite an admission of paying me 25%, reducing 25%, they have not paid.
That's why they have admitted. So go. What do you want? Come on the next day.
But I'll take instructions and come on the next day.
Not today.
Grateful, lordship.
Next. ये 11:30 मैटर है 12:30 12:30 क्या तो नहीं होगा Mr. Shah, only 7 minutes is there.
Yes.
Can you come at 12:30?
Yes, my lord, we can do that. Mr. Sarkar is there online.
Very well, madam. Come at 12:30.
12:30?
Yes.
So I will give one hour to you both of you.
Well, I'm good.
My lord, may have to join online with your lordship,
No
please,
problem.
because my lord.
This court is not having problem to joining online.
No.
Much obliged. Come at 12:30.
I'm good.
appear for the PT.
Yes, supplementary affidavit be filed within 2 weeks. You are
And the
for the
petition plaintiff that has been filed.
Ah.
Learned senior.
You filed the supplementary affidavit?
Yes.
When? Supplementary affidavit hai?
It is in the well, my lord, I'm praying for a short Passover. Learned senior advocate Shantan Basu is leading.
Not today. Not today.
No, not Passover.
Passover, none, there is nothing. 12:30, 11, all the matters fixed. Yes, next.
18 transfer. Transfer.
18.
Mate, please, my lord. My lord, 18 and 19, my lord, are same, my lord, suit filed by the same plaintiff against different defendants. Application, my lord, for direction on the defendant to disclose the original agreement. Your lordship may kindly remembers
Not computer the argument and fit for time.
in this application, my lord, what has happened? Sorry, in this suit, my lord, the suit is being proceeded as ex parte suit. My witness during his course of examination has deposed that the original agreement is with the defendant because copies have been retained with him, original is with the defendant. While tendering the document, your lordship has marked the document marked as X for identification. So, my lord, to prove the document through secondary evidence, I have given him notice to produce. I have complied under Order 11, Rule 5. Now, my lord, I am seeking a formal direction. This is an application under Order 11, Rule 5 upon
What is the application?
Lord, these two applications which are appearing, your lordship. Lord, this
GA4.
GA4, my lord, in both the suits, your lordship may kindly sees.
What is the prayer?
Kindly sees my
GA4?
prayer. My prayer is very formal in
Directing
nature.
defendant to produce the original.
Yes, my lord.
Of the container lease agreement.
We have already given a notice to produce, and I have, my lord, tendered that notice to produce also during my chief. But not this. This document your lordship has marked is as for identification. So until unless, if I, my lord, under section 66, your lordship is aware, my lord, that until unless that step is complied with.
That's why on the last occasion.
Yes, my lord, that is why it was adjourned.
Take
So,
appropriate steps.
yes, my lord. So that is
you
why,
want a direction upon the defendant.
on the defendant to disclose, my lord. So that if they don't, my lord, then my alternative prayer is, my lord, that my lease agreement be
Where
marked.
is the notice to production prior to this? Where is
Your
the
lordship may kindly sees it's at page 10, sent through email, which is at page 11. In both the matters, my lord.
Mr. Altama Salim Lana, advocate appearing for the plaintiff, submits that the case of the plaintiff is based upon the agreement dated.
Lord, December 1 in, Lord, in two suits are different. So first is
first one.
December 1, 2017.
Agreement dated 1st December
SM
2017.
containers. The first one is SM container.
And the plaintiff has produced the copy of the said agreement before this court at the time of examination the plaintiff witness. And this court has marked the said document as X for identification.
X for identification.
X for identification. Full stop. The plaintiff had issued and full stop. Consider Mr. Alim submits that the defendant is not appearing in the matter and suit is going ex parte against the defendants. Defendant or defendant?
Defendant, sole defendant.
Against the defendant. Accordingly, the plaintiff had issued a notice to the defendant by an email dated 24th of February 2025 requesting to produce the container lease agreement dated 1st December 2017 executed between the TransSafe TRANSAFE TransSafe Services Limited within bracket TSL and SM Containers Line Private Limited. He submitted that in spite of receipt of the said notice, the defendant failed to produce the said document, produce the agreement dated 1st December 2017. Accordingly, the plaintiff has filed the present application being GA Com 4 of 2025, praying for a direction upon the defendant for production of the original production of the original container lease agreement dated 1st December 2017 entered between the parties. Heard the landed counsel for the plaintiff. This court find that the plaintiff is at the time of evidence of the plaintiff witness, he said the agreement was marked as exhibit marked as X for identification, and subsequently the plaintiff had issued the notice to the defendant for production of the original document, but the defendant failed to produce the same. Considering the above, the defendant is directed to post production of the original container lease agreement dated 1st December 2017 executed between France से कोई वाला party है and so and so before this court on on 26th of August 2020.
26th, yes.
26th of August. The plaintiff is directed to take appropriate steps for issuance of subpoena upon the defendant for production of the document.
And Lord, another matter, Lord, the order, Lord, subject to correction will be same. Only the date of agreement will be 1st June 2018.
Parties are same.
Parties, no, parties are different. The agreement is different.
GA3.
GA3. Defendant is different, agreement is different.
इसमें आएगा सब कुछ आएगा. Lease agreement dated 1st June 2018. ठीक है, entered between Tranship Service Private Limited (TSL) and PROCEEDINGS PROGREDIRE Shipping Private Limited. Yeah. Hold कर दे. दोनों 26. Plaintiff is directed to take appropriate steps for issuance of
26th of August.
both GA disposed. That is
The next matter.
18-19 है ना? 18-19 दो अलग अलग. Yes.
Before your lordship takes up the 11:30 matter, it's very
Yes.
the next matter is very short matter. My lordship had inquired whether they have filed the written statement. They were given leave on 18/6/2025. Now the extension application was within, but they on last occasion they could not say whether they have filed it with the department.
My lord,
So
written
that is all.
statement has been filed, my lord, on 16th June 2025 in the department.
No, the leave was given on 18 June. Could not have been filed on 16 June, perhaps. If it is on
have the
record, that is
copy.
all. If it is on record, that is all.
I have the copy, my lord.
My lord, they might have affirmed it within time, but they could not file on the last occasion. It has been clarified by your lordship, my lord.
Filed, my
And
lord.
they had admitted that it was not filed in the department.
एक काम
And
करो.
order 8 rule 1 is attracted in that score.
डिपार्टमेंट बोले फिर उन लोगों को पूरा डायरी रजिस्टर लेके घूमना शुरू हुआ. मास्टर से पूछो अगर रिटर्न स्टेटमेंट है तो यहाँ भेजने के लिए. कम टुमारो.
Very well.
Yes, call them.
Grateful, my lord.
I appear for defendant number 2 and 3.
My lord, I have made a compilation of the orders of this honorable court.
Yes.
My lord, I'll give a copy to my learned friend. Well, this is for your lordship. You know? এইভাবে কি করে হবে? দিচ্ছি, আপনি কিন্তু আপনার ওইটার কপি দেননি, যেটা জজকে নোটস নাকি একটা তুলে দিলেন না, তাহলে কেন কপি পাবেন? প্যারিটি মেনটেন করতে হবে না, আপনি দেবেন না আপনাকে দেবো। Millard, this is Millard my answer. Millard, I'll take Millard the limitation first. Millard, you find Millard page 1 is the first order passed by this honorable court. Millard passing an order of injunction. Then, my lord, it goes on. My lord, I will not bother your lordships with that. My lord, extended. Now, my lord, will kindly have a look at page 11. Page 11.
Yes.
This was also a part because it's a part of their application. Now, my lord, this is the, my lord, sending back of the, my lord, kindly see the date at the top. December 22, 2015, type at the top left hand side.
Yes.
Now, my lord, on this date, my lord, will kindly see the next page, serial number 5. It is noted that the claimant has raised claims. Next page, 12. Continuation of page 11.
Yes.
It is noted that the claimant has raised claims for the amount of rupees such and such, which is 31.7% of the total contract value, which is more than 20%. Hence, the arbitration agreement cannot be invoked. Similarly, it was returned.
Yes.
Similarly, this had concluded in 2015 itself. Now, I will kindly turn the page. Page 13. This is Millard. We received the Millard 22nd December notice a few days later. This was the immediately next date. Millard, when Millard, their Section 8 application was taken up, when Millard, both the senior counsels Millard have left us now, Millard. Both of them Millard have left us. Millard, they had agreed, Millard. Kindly see, Millard, the next page, last paragraph.
Yes.
By reason of the recent amendment of the Arbitration Act promulgated and given effect to and or from such and such, the court is of the view that the matter may be referred to arbitration. Mr. Ghoshal, Mr. Chatterjee, and a senior counsel representing parties has assured this court that they shall consider the matter. By the time, Millard, the letter has not reached us, means the returning back. Now, Millard, kindly see the next page, page 15. Mr. Ghoshal, learned senior counsel representing the claim, applicant submits on instruction that his client is not inclined to, but by the time it has reached, not inclined to proceed with the instant application and press for dismissal thereof. So it was dismissed. So Millard, the claim came back. Now, Millard, kindly see reply, rejoinder, supplementary affidavit. I am not bothering your lordship with the. Now, Millard, kindly see this is page 18. Millard, this is my notice under section 80, subsection 2. Millard, this is I'll let Millard the exhibit to lordship, exhibit X, PD 24 exhibit X. Millard can mark Millard at the top.
Exhibit X.
Exhibit X, PD 24. When Millard, I crystallized my claim by giving a notice under section 82 of CPC.
1911-16.
Absolutely. These are all Millard happening within time. Now, Millard, kindly turn the page, their reply at page Millard 23. No, not Millard 23. It's at page 24. 24. This is Millard, also an exhibit. Exhibit T and common document. PD 25, DD 39. So as a common document, exhibit T.
Exhibit T.
T. So this is also of 10th January 2017. So within 3 years. Now, I will kindly come to page 30. I'll skip the next order. April 2017.
Yes.
My amendment application incorporating those claims, which was written by the learned arbitrator.
Yes.
It is key. Huh? No. No, sorry. I'm so sorry, Millard. Kindly take page 32. 4th May 2017. This is an application for amendment of plain. Written at the first line.
Yes.
Millard, this amendment was allowed at page 33.
Yes.
The claim which was returned by the arbitrator was inserted. Now, my lord, kindly comes to page 34. My lord, I usually cite this order in case of amendment. My lord, kindly see the first line of that judgment.
Yes.
Justice Banerjee can write this. Now, my lord, this was the appeal was rejected.
I remember in one mandamus appeal I filed and it came before Justice Banerjee sitting in the division bench. I argued the matter. He had me about 25 half an hour. Then he started dictating. This same drum is beaten by the same stick.
It's a flavor to his. Now, Miller, 10th November 2017, Miller was looking for this order. When they were injuncted, my injunction application was finally disposed of. 10th November 2017, injuncting them. Miller, from
what is this page 34?
34 is the appeal.
Appeal.
From amendment, the Union of India had carried out appeal.
Okay.
That was Miller knows from the first line. Miller can see what will be the last line.
Yes.
So Miller, that was rejected. So there it has not been carried to Supreme Court. So it has been put to rest. Now 37.
Yes.
This Miller disposing of my GA of injunction. Miller, it's the application for injunction, which was Miller considered and disposed of at page 52. Will find disposed of. Then Miller.
Bank guarantee should
Yes.
be renewed
Yes.
at least
51.
15 days prior to the date of expiry upon integration. Failing with the defense will be entitled to invoke the bank.
They carried an appeal. They carried through appeal. This also Millet can see hotly contested page 53. Millet can note the dates. This page 53. This in the midst we lost Mr. Chatterjee. Now the appeal was allowed. Then kindly see at page 69 will find.
No, 53.
69, the inference.
What? 60.
Appeal allowed.
Yes.
Now kindly turns to page 70. Because it was a separate contract, settled law, which was
No reason to entertain. Decide the expedition.
page 70 SLP.
Yes.
Similar direction upon this court to dispose of the suit within 6 months. Anyway, it's in 2019. Now, kindly takes. Yes, we are within 6 years.
What is the date? 19.
19. Can't be helped. Series of change of determinations and all those things. COVID came in the meantime. Immediately COVID came.
Even though it is very difficult in the civil, or whatever either civil criminal, time bound, it is very difficult for the court.
Very difficult. I recollect, I had the occasion to appear in that matter before the Honorable Supreme Court. Justice Bobde was the Chief Justice, and Justice Bobde was sitting in middle. And both Justice Gawai now, who is the Honorable Chief Justice, and Suryakant, they were against me. Only Justice Bobde was in my favor. But this is his insertion of second paragraph. If you go back with some. But the only thing is, by the time they encash the money, it has already left the coffers. That was the only reason. It took time, it takes time, in SLP also. Every page has to be photocopied, retyped.
This may not be correct, Lord. This may not be correct. I have instruction that after this.
আরে আমি ছিলাম, আমি গেছি, নামটা দেখুন অ্যাপিয়ারেন্স।
Okay, that is neither here nor
না, এমনি নিজের মামলা বলতে পারছি।
Disposal of this SNP, this encashment.
Now, Milad, kindly see Milad next page. Milad, we filed a second set of amendment application. Milad, when Milad the amount of Milad bank guarantee was incorporated. 12th, this is the last day of court prior to COVID.
Yes.
Kindly mark the date. We stopped court on 12th of March 2020. Now, Milad, it was allowed on contest. Now, Milad, kindly takes page 78. Another appeal was preferred. Now, Milad, kindly have a look to this. I have more to say, not relating to this matter. Milad, few of the matters in 2021, it was settled. Kindly see Milad 6 January 20, page 78, division bench. That Milad anything which Milad the amendment to Milad the appeal was disallowed on the ground that not under 13.2 is barred. Order 43 doesn't allow from amendment. Now, the interesting part of, well, kindly don't take me amiss. This bench same bench had passed 5 different judgment at same point of time. Allowed, disallowed, allowed, same point. Order 43. Even if not, I am allowing. This is the confusion that we are facing from my lord's order of good faith when my lord had revoked the 12A. Now, my lord, they have preferred an appeal. I took a point that not written in order 43. Now, the appeal court is hearing on this point whether appealable. I have been successful in not getting it admitted. On this point that order 43 or 12A not written. So, my lord, they showed a judgment of Srishti infrastructure, where the same bench had said that appealable. I showed plethora of judgments of the same bench at same breath during same point of time, where the same bench has said disallowed. The division bench now is in turmoil which judgment to follow and which not. Difficulty is the same bench, same judge.
Yeah, that's why if it is coming to this court also, it is very difficult.
Difficult. My lord, get this difficulty, and my lord, kindly don't go by a judgment, because the same bench will have a separate 4 judgments.
I know. That's why 1 or 2 matter I referred.
It has to be.
Otherwise, it is.
And my lord, difficulty past is that 2 honorable judges are same bench.
Correct.
My lord, we are facing the now difficulty.
That's why one
They are
party is
showing one
this,
judgment.
one party is showing this.
I am showing the same bench, same judgment.
What this court will do? And binding on both.
Court could not had to appoint an amicus in that matter. Good faith.
Okay.
Now, my lord, this is on the very first time when Commercial Act came. This bench held that my lord, order 43 is not under order 43 is not appealable. Appeal dismissed. So, my lord, this is how, my lord, I answer to the issue of point of limitation.
Yes.
That means these are all within. Now, coming back to the issue,
That's why under the commercial order, the bar is facing problem with regard to the appeal.
Because now the task is upon me.
Correct.
That to search whole night that the same bench has passed a different one in my
That
favor.
is one aspect. Even because if you go by this, if it is appealable, it is not appealable, then go to Delhi.
Has to be.
Correct.
Because everybody is saying that don't take this one because next day you will be in difficult. But what can be done? I cannot take my court to a take this honorable court to a wrong way by saying. Now, the learned senior advocate who is now appearing against me is showing that this judgment is in my favor. Within 2 minutes, I am sitting, searching this judgment in my favor. I am handing over the tab. So the honorable judge, the division is going to admit it. Within 2 minutes, sorry, we can't.
Very difficult. Yes.
Now, Milad, kindly takes Milad the questionnaire Milad May 2, 2024 of Arpit Khunteta DW1. Milad, I was going through, Milad, I found one clinching issue which I thought that বলিনি বলছি স্যার কাইন্ডলি ওই তো প্রথম পাতা থেকে 25
Question 25.
25
Yes. This is also the limitation?
no next issue Miller I am on this limitation point Miller is over
Okay.
Miller I think Miller I've tried Miller I've been able to satisfy your lordships
Okay.
Miller worry on this because Miller with regard to limitation my 82 notice was much within so it has crystallized now Miller this is with regard to Miller far more fundamental and it goes to the root kindly see the Miller question number 25 on the last occasion in answer to my question regarding an authorization to depose before this court you had submitted an order of railway dated such and such my lord you recollect this which has been kept in record for I am showing you the document which has been duly authorized by the defendant number 2 would you please specify what is the document this is the authorization kindly 26 kindly tell before this court what is the document this is authorization document where I am being authorized by defendant number 2 then my lord questions come what is the date of authorization 24th April 2024 now my lord immediately my lord put the next question then on which date you have deposed before this court he said 12th April 2024 so you admit on that date you are not having authorization on 12th April the internal department note sheet I was instructed to appear as a witness and I appeared on the basis of that and in that hearing I am was instructed to bring the authorization letter and I produced this as per the court's order show me the order passed by this court directing you to produce the authorization this is the first time I have been involved witness before this court my understanding was that previous hearing I was instructed to produce authorization now my lord will find the authorization has not been exhibited. After my lord I put the question, my learned senior friend went on Millard examination and examination in chief, examining in chief Millard the witness. Millard, I believe Millard I am correct. Millard the authorization has not been exhibited.
Okay.
So Millard, if it has not been exhibited,
what is the value of the
what is the value? Absolutely. Similarly, entire evidence goes. I have gone through Millard, there is no exhibit.
Yes.
Now, Millard, I have CPC to যেতে গেলে রোজ এমনি CPC নিয়ে ঘোরা আজকাল CPC দিচ্ছি
Yes.
Kindly have a look to Millard order 3 rule 1 appearances etc may be in person by recognized agent or by pleader any appearances application or act in or to any court required or authorized by law to be made or done by a party in such court may except where otherwise expressly provided by any law for the time being in force be made or done by the party in person or by recognized agent or by pleader appearing applying or acting as the case may be on this behalf provided that such appearance shall if the court so direct be made by the party in person Millard, there is no scope for Millard deposing so it's acting, appearing, applying. That's all. So,
No, order 3 rule 1 with regard to the appearance of the parties in the suit.
Yes. No, I was searching. Millard, I got a 2024 judgment of Justice Pardiwala. Millard, this Millard, there has to be a special authority to depose. Millard, I have gone through the 1992 authorization also because the next witness, Mr. Ekka, who appeared, he had deposed before lordship on the basis of that 1992. And Millard, my will find I am carrying the copy that has been also been exhibited. My will find that only said to act. It does not say to depose. So if it is to act, it can means to appoint a pleader or sign or verify pleadings. Deposing is altogether different for that. There is a separate authorization that you usually do. file the authorization letter or the resolution of the company. In this case, we have also done. Now, apropos this, my lord, I'll be relying upon a judgment of Honorable Supreme Court 2024 6 SCC 130. SCC 130. And you kindly take paragraph 28. Page 139.
Para 28.
28. The law, the law as understood earlier was that a general power of attorney holder, though can appear, plead, and act on behalf of a party he represents, but he cannot become a witness on behalf of the party represented by him, as no one can delegate his power to appear in the witness box to another party. However, subsequently in Janki Vaishno Devi Bhojwani, this court held that the power of attorney holder can maintain a plaint on behalf of the person he represents, provided he has personal knowledge of the transaction in question. It was opined that the power of attorney holder or legal representative should have the knowledge about the transaction in question so as to bring on record the truth in relation to the grievance or the offense. However, to resolve the controversy with regard to the powers of the general power of attorney holder to depose on behalf of person he represents, this court, upon consideration of all previous relevant decisions on the aspect including that of Janki Vaishno Devi, and such, concluded by upholding the principle of law laid down in such and such, and clarified that power of attorney holder can depose and verify on oath before the court, but he must have witnessed the transaction. Mr. Khunteta has said that I have no personal knowledge.
He appointed subsequently.
Yes. As an agent and must have the due knowledge about it. The power of attorney holder who has no knowledge regarding the transaction cannot be examined as a witness. So, my additional to the limb that the witness has his resolution has not been exhibited, more so he could not be produced as a witness because he was employed in 2018.
Yes.
He could not have he has said in depose that I don't have any personal knowledge. The functions of the general power of attorney holder cannot be delegated to any other person without there being a specific clause permitting such delegation of the power of attorney. So, even if we fall back to 1990, this for Mr. Ekka, fall back to 1992, there is only to act, meaning thereby ordinarily there cannot be any subdelegation. It is therefore settled in law that power of attorney holder can only depose about the facts within his personal knowledge and not about those facts which are not within his knowledge or are within personal knowledge of the person who he represents, or about the fact that may have transpired much before he entered the scene. Mr. Khunteta. The aforesaid power of attorney holder PW1 had clearly deposed that he is giving evidence that we have plaintiff 2 and 4, the galas, he was not having any authority to act upon the factual is so my contention before Lordship is on two grounds. First, his authorization not exhibit, so my lord, there is no question of looking into his evidence. Even if my lord intends to look in, he had said I was appointed in 2018. So admittedly, he has no personal knowledge. The issue prior to this and Bhojwani, Miller, I also said seen Bhojwani, Miller was that he cannot enter the witness box. Miller in Bhojwani, Supreme Court took a liberal view that yes, he can, but he should have a personal knowledge. This has been Miller further affirmed by this judgment, recent judgment of 2024. Now, Miller with regard to Miller, Mr. Ekka. Now, Miller kindly comes back to Miller the deposition again. No, Miller kindly sees Miller, Mr. Khunteta's deposition of August 2, 2024.
Question number?
Question number 154, 153.
Yes.
So where Millard it's Millard first Millard let me Millard I'll come back to this later. Millard kindly takes Millard Mr. Ekka's Millard let us finish this part. Mr. Ekka's Millard of 1 days only, November 28, 2024.
Yeah, DW2.
DW2.
Yes.
Millard kindly see. Millard, I am showing you one document.
Question.
Millard, question 1.
Yes.
আমার কাছে ছিল so many papers and documents. Millard, একটু exhibit 13 টা বার করে রাখবেন exhibit 13. I am showing you one document. Kindly tell the honorable court what is this document. This is a letter of authorization. This was given to my deputy engineer construction to Vilaspur. Marked as exhibit 13. Now Millard kindly takes Millard the cross examination. Pay a question number 47. Under which power under which power did the deputy chief engineer have the authority to authorize you to depose? Page for question 47.
Question
In cross examination to Mr. Ekka.
47.
47.
Yes.
Under a file.
How are you authorized?
Under which power did the deputy engineer have the authority to authorize you to depose? There might be some railway board. So Millard, he is not aware of railway board order. Now, Millard, kindly come to question 4 of the deposition of Arpit Khunter of 12th April 2024 shown. Now, Millard, 12th April 2024, Millard, this is Millard, the 1992 resolution was shown to him. According to you, is this the railway board order by which the deputy engineer authorized you? 48. No. Ekka. He said yes. Now, Millard, kindly have a look. So, Millard, he falls back on 1992 authorization. Give me a moment. Millard, 1992.
Evidence Act.
Millard, 1992. Yes, Millard, I had a copy, Millard, of the 1992. Millard must have seen several times this.
Yes.
Kindly see the last line of first paragraph. To act.
Act and for on behalf of the Union of India in respect of any judicial procedure.
So, Millard, by the dint of this authorization.
This includes everything. No?
Sir, please.
The act includes everything. To supervise railway is so big organization.
No, that's correct. See, act in the organization, in the establishment of any of the government or semi-government or any autonomous body, there is a circular like this.
Yes.
It is not necessary the concerned officer can go and file affidavit and file.
Yes.
It is in the name of, but in your case, that's why since beginning when the PW1 was examined, Again and I am telling that, see, Mr. Drolia, you will be in difficulties. The authorities who are the main persons are not coming in the dock and sending
I'll
the
come to
second
that
person.
question.
Look, here, my lord, here, my lord, these are the officers who have been authorized by the board, and that power derived.
If the deputy chief engineer is available and he is giving the authorization to the any person, what prompted your deputy chief engineer to come before this court to examine, though he is a defendant number 2 in the suit?
My lord, here, my lord, if there are
Because he is a much more higher than the court.
that is not so, my lord.
So why he has not come?
My lord, here, my lord, there is a
Then
very
they have to face the
urgent
consequences.
works that's to supervise by the deputy engineer, my lord.
What?
Urgent works of this, my lord, the tracks and
all the
like-
letters have been signed by him. In his presence, all the work has been. He is the decision-taking authority. He was the decision-taking authority.
Moreover, this pertains to Bilaspur, and the jurisdiction is there. If it would have been there, the deputy chief engineer would have been there. But here it is to come to Calcutta.
So he is not able to come to the Kolkata.
Milord, this Milord, by the board, railway board, 1992 order, Milord, that is from the under the CPC. The CPC, Milord, that this has been authorized, and under that provisions, Milord, these provisions have been made by the railway board that these officers are authorized.
Okay, if I will accept your submission, Mr. Drolia, I accept this court, accept your submission.
Yes.
Yes, he is able to come and depose.
Yes.
But what your witness stated, he is not aware of the personal knowledge of the document. If the
Personal knowledge means what? Milord, whatever the documents lying in office, he has gone through entire file. Then it becomes a personal knowledge.
Okay.
It's not a hearsay.
Okay, thank you.
So, my lord, kindly see it's only to act. My lord, I rely on again, my lord, at the cost of risk of repetition, my lord, the judgment of 2024 6 SCC. Act doesn't include, my lord, to depose. So, my lord, the deputy engineer.
This is exhibited, no?
No, this was, my lord, refused by your lordship, my lord. But he has relied upon this, my lord, that on the basis of this, the daily order was passed, which is exhibit 13. This document was shown from Mr. Khuntetar's examination. The question was put that whether this is that document. He said yes. So this is the mother document. So deputy engineer didn't have the authority to depose himself. He had only the authority to act. Mila, the act is very clear by the Supreme Court judgment. Mila, there has to be a specific authority to depose.
No. See, act is with regard to the order. But if the deputy chief engineer is a party,
he should have come himself.
That's not no. What you have submitted,
yes.
The deputy cannot. He can act. He can depose if he is a party.
Party.
Yes.
Now, Milord, kindly see. This Mr. Ekka had also not didn't have any knowledge. Kindly see, Milord. Next, kindly turn the page. Do you have anything? Page 50, question 58. Do you know anything about the claim of the plaintiff in the present suit? I have not seen that. Question 58. Do you know as to whether the railways have claimed anything in present suit? Yes, railways have claimed. What is the nature of the claim of the railways? The railway had defended the matter. So he has no clue what is going on. Now, Milord, 61. I put to you that you have no knowledge about the present proceeding. I have not seen properly. Now, Milord, my lord's question number 62. Do you know whether two persons, Ashok Kumar Suryavanshi and Mr. M.B. Satyana, are still in service? He said yes. So if the authors are in service, he had no occasion to come and depose before your lordship.
Yes.
Now, this is, Milord, my contention is that both the Milord witness, Mr. Khuntetar's witness cannot be looked into, even if Milord, if you would have deposed, Milord, given the exhibited the resolution. Now, Milord, regard to Mr. Ekka, he has no clue what is the matter about. And when both of them are in service, he has no locus to come and depose before your lordship.
Yes.
Now, Milord, coming back to the Milord, the investigation report, Milord, for that which was, Milord, kindly comes back to Milad, have a look Milad, August 2, 2024 deposition of Mr. Khunteta. Kindly comes to page question 153.
Yes.
So where does it say that geotechnical investigation has to be done by the railways and the contractor cannot proceed with the geotechnical investigation until and unless the railways give the assent? With regard to the first question, as I can recall, it is a railway board policy that before finalizing the tender, the geotechnical investigation should be completed. According to that policy, railways had conducted the geotechnical investigation. Secondly, as mentioned in clause 19, it clearly states that any work which has to be started, started the work order shall be given in writing to the engineer before starting of the work under contract. Which policy are you talking about the railways? Have you disclosed? I do not remember the exact policy number because there are a lot of policies and guidelines. If you got, I can produce. Have you disclosed anything in this suit? I do not know. So when the railways carry out geotechnical investigation, what happens to schedule A and cost mentioned therein? And also the scope and purview of the contract. In the contract agreement, special conditions of contract, chapter Roman 6, agreemental conditions, clause 1.32.2, power of modification of the contract, which clearly states that the engineer on behalf of the railway shall be entitled to order in writing to enlarge or extend, diminish or reduce the works, or may any alter in the design, character, position, slight, quantities, dimension on the method of the execution, or in combination or use of the materials for the execution thereof, or to order additional works to be done or any works not to be done, and the contract will not entitle to any compensation. So Millard, he relied on policies, but he said he is not aware of and he has not disclosed. So Millard, his answer to Millard, the query and the question put in question of 153 and 154 remains Millard, that has not reached the logical conclusion. So Millard, he could not show Millard what are the policies on which geotechnical investigation can be done by railways. Now Millard, I will come to the first issue, and Millard, request my lord to note the question numbers, and I will put in my notes. The first issue was that, now I will go Millard issue wise. Millard, with regard to the issue which are at the issue number 12 and 17, I believe Millard I have dealt with because it's just regard to the counter claim and written statement. Now Millard, kindly comes to Millard. The first issue is that is the suit maintainable as framed? Millard, in examination in chief, kindly marks Millard question number of Mr. Pradeep Khaitan, PW1. Examination in chief, the question numbers are which are put to this on this Millard 71 to 89.
71
to 89.
Yes.
195 to 206.
Yes.
My lord, in cross examination of PW1, the question numbers are 211 to 213. 211 to 213, 222 to 226, no, 222 to 237, 252, 257 and 258.
Yes.
Once I can start reading, but those will consume the time unnecessarily.
Not required.
Millard, kindly also marks an exhibit here, exhibit G, because Millard will find Millard many documents are in Millard photocopy. Millard, exhibit G is my Millard, my first information report given to the police authorities that the documents are lost, and that is exhibit G. And Millard had allowed secondary evidence to be laid.
Yes.
Exhibit G. Now, the issue number 2 and 5.
There is no specific order that secondary evidence is allowed.
It has to be proved. Court cannot pass an order. The secondary it has to be proved.
He said that
প্রত্যেক ব্যাপারে তাহলে তো মুশকিল না, আপনি বলে গেছেন 7 দিন আমি বলিনি।
No, it's correct, correct. The court cannot pass and the second or allowed. They have to prove.
Yes, I have to point out if there is a incorrect.
Yes.
Duty, right?
হ্যাঁ এটা আপনাকেও করতে হবে আপনার পাবলিক ডিউটি
Yes, next.
now Milad issue number 2 and issue number 5 Milad can take up Milad simultaneously. Whether the plaintiffs fail to perform any part of the contract despite the same being achievable under the contract conditions. This was issue number 2. And issue number 5, whether it was the plaintiffs who were alone responsible for the delay in the performance of the reciprocal promises under the contract, or whether such delay was attributable to reasons beyond the control of plaintiffs, including force majeure conditions.
Yes.
Malad PW1 examination in chief. Malad kindly notes Milad the question numbers 12, 37, 38, 40 to 43.
12, 37.
38.
Yes.
40 to 43 means 40, 41, 42, 43. 45 to 50.
Yes.
89, 90, 99, 100 to 107, 122 to 128, 129 to 135, 136 to 146, and 158 to 174.
36 to
146.
And
158 to 174.
yes.
I mean, in cross examination of PW1, let 239 to 241, 253, 259, 261 to 268, 278 to 282, 289 to 293 and 297.
289 to
293 and 297.
yes.
Now, PW2 was an expert witness, engineer. Now, his examination in chief, PW2, is 23, 34, 35, and 81.
Yes.
PW3, there is one question in cross examination because he was relating to accounts, so there is no scope for him to much delay. 218 in cross examination of PW3.
Yes.
And the exhibits Milad will have to look into is the first tender notice, exhibit E.
Yes.
Second tender notice, exhibit I.
Yes.
And 2 letters, exhibit MMLL. MMLL.
Yes.
Now, I'll come to issue number 3 and 4. If I get one more day, 15-20 minutes, I'll conclude.
Yes.
I'll try to even do it today hurriedly, Milad, and put it in my notes. Then, Milad, the issue number 3 and 4, Milad can take up, Milad, jointly. Milad, PW1, examination in chief. But I'm not reading the issues. Those are there in the order. Examination in chief, 13, 29 to 50, 70, 99, 101, 107, 147 to 157 as PW1.
157.
147 to 157.
Yes.
And 175 to 185.
175
to 185.
Yes.
In cross examination, it's 254 to 256, 272 to 277, 283 to 287.
Yes.
294, 304 and 305.
Yes.
Milad, PW2 in examination in chief. PW2.
Yes.
Question number 9 to 22.
Yes.
24 to 33. 40, 47 to 80. 82, 83, 85 to 99. 102, 103 and 105 to 119.
Yes.
PW3 in cross examination. Question number 203, 204 and 217.
203, 204.
And 217.
Yes.
Issue number 6. Whether the 7 days and 48 hours notice were valid or not. PW1. Examination in chief 89, 90, 100, 101 and 186. In cross examination 297 to 299.
Yes.
PW2 in examination in chief 37 to 39. That's issue number 7. Whether the contracts to discharged or not. PW1 examination in chief is question numbers 37, 38 to 42, 45 and 48 to 50.
Yes.
Cross examination of PW1 question number 288.
Yes.
PW2 examination in chief question number 41.
Yes.
Issue number 8 and 9. Whether the invocation was proper or not. In chief, examination in chief of PW1 question number 58 and 56, 55 and 56. In cross examination question number 288.
288.
288.
Yes.
Well, issue number 10. Whether the plaintiffs have become entitled to compensation for the loss sustained. And issue number 11. My lord can take up jointly. What sums the plaintiff is entitled to. PW1 examination in chief 39 to 42. 57 to 60. Cross examination 300 to 303. PW2 examination in chief 100, 101 and 104.
Yes.
PW3 examination in chief. This is the entire deposition 14 to 191. He came for accounts part. We have Millard give quota files 17 files of vouchers, the bills, handwritten bills. I'll give these exhibit numbers, Simon. 14 to 191 in examination chief of PW3. Cross examination 205 to 216, 219 to 221. Milad issue number 12. With regard to the counter claim.
Yes.
Examination in chief of PW3 133 to 136.
Yes.
Question issue number 13. Whether the reliefs and further is entitled to P1 examination in chief 51, 52 to 54.
Issue number 13.
Issue number 13 PW1 examination in chief.
Yes.
51, 52 to 54. Then want of cause of action issue number 16.
Yes.
Examination in chief of PW1 58 to 70.
Yes.
Rest are the issues with regard to written statement and all those I have started showed to lordship last day. And with regard to limitation, there were no questions put. That is issue number 15. With regard to issue, that's for my learned senior friend to put question. I could not find any question on that. Can note for that reason it's straight to 16. 14 also, whether the suit is barred by principles of waiver, estoppel and acquiescence, no question put. Can take a note.
No, with regard to the waiver and this, what is your answer that you have submitted an application for foreclosure?
Yes.
So if you ask for the foreclosure, their submission, their case that you ask for the foreclosure, how you can claim the damages?
No, the foreclosure, the foreclosure which was submitted, it was the demand of the situation. For that, I will be relying on section 56 of the Indian Contract Act. If due to supervening impossibility, I cannot be held to be responsible. Because section 56 says agreement to do impossible act. An agreement 56
Yes.
An agreement to do an act impossible in itself is void. Contract to do act afterwards becoming impossible or unlawful. A contract to do an act which after the contract is made becomes impossible or by reason of some event which the promisor could not prevent, unlawful becomes void when the act becomes impossible or unlawful. Compensation for loss through non-performance of act known to be impossible or unlawful, where one person has promised to do something which he knew or with reasonable diligence might have known and which the promisee did not know to be impossible or unlawful. Such promisor must make compensation to such promisee for any loss which such promisee sustained through the non-performance of the promise. So, I invoke here the section 56 that the geotechnical report which was handed over was wrong. Mr. Khunteta could not show any policy decision which says that geotechnical report will be carried out by the department, not by the contractor. Question number 153, 154.
Geotechnical report, who has submitted?
They have submitted.
They have submitted. What
They have submitted. It was within my scope.
Correct.
First tender, it was within my scope. BOQ says that it has to be done by me. It is nobody's case that geotechnical report has done by us. Both of us says an addendum on this issue that geotechnical report has been done by Vision Lab of Hyderabad, and handed over to the contractor. My valuation has been reduced. When I proceed with the geotechnical report, I found that well foundation is impossible. Because millet, for being well foundation, I first require millet a license for blasting. And millet, with regard to millet well foundation in a river bed, which millet PW2 has answered, millet I noted the question numbers, that well foundation is not at all accepted in a river bed. And we had suggested, millet, the exhibits are there, millet MMLL. We have suggested millet piling. Now, millet piling was accepted by them when millet they floated the third tender, which in return millet strengthens our technology or methodology to be followed of millet piling. So millet, in that, with that dint of the matter, millet I had invoked section 56, and I cannot be held liable for any repercussions or any financial repercussions. Okay. My lord can correlate, my can also note, correlate question issue number 2, 5 and 14 together. That they need to become clearer to my lord. When my lord will be going through 2, 5 and 14, because it should be taken together, because it was 2 and 5 are impossibility, responsibility, and millet 14, principles of waiver, estoppels and acquisitions. Now millet, with regard to millet exhibits, my lord will give me any day 10-15 minutes. I have judgments are ready, but I believe millet there is a 12:30 fixed matter today also, millet. So my lord will give me 10 minutes any day, 10-15 minutes. Kindly put it at the millet top. No need to require millet fix a time. Give me 10 minutes any day. By the clock, I'll just put these judgments and put it in my note and conclude. It's done.
Yes. My lord, I have to reply.
Now for my conclusion.
Sure.
Counsel for the plaintiff has argued the matter at length, but due to paucity of time, hearing could not be completed. This is the matter. मैंने कोई डेट है ये मैटर? क्या में है? स्पेसिफिक्स में नहीं, यहाँ का को ये असाइन मैटर नहीं है ना. Problem is the date.
Millet, any day, Millet keeps it at the Millet as the number one item. Millet, I'll take 10 minutes. I'm almost finished.
Milord, after my learned friend concludes, Milord, then kindly give me 2-3 days time, Milord, to give my reply, Milord.
Millet can also keep it on Monday. I can finish within 10 minutes. I'll not hold the bar back, Millet, on this.
Let the matter appear on 13th August at the top, under the heading argument.
13th August, Millet, at the top, Millet, so that the matter can be taken up. Great. Millet, that 1992, Millet, I'll make a copy and give it to your lordship, Millet.
1992.
The authorization. I'll just make a copy.
Yes, next. Book गिरा. Yes.
Yes, Milord, may I, Milord, can your lordship hear me, Milord? May I start?
Yes.
Yes. Now, Milord, a substantial argument has been made on the construction, Milord, of this contract, and Milord, Section 55 cases have been cited.
Correct.
So, Milord, lordship has to then examine, Milord, what the contract is all about. This is, Milord, a lending contract by a financier, Milord, Piramal, like, Milord, a banking transaction. Now, normally, Milord, payments are made, Milord, quarterly installments, they have to be repaid by the borrower.
Yes.
Now, Milord, here the essence in my submission of a financing transaction, that, the lender must have a right to, Milord, recall the loan on the event of default. Now, my learned friend's whole argument has been that, my lord, this event of default, my lord, recalling here has no my lord, impact at all, which, my lord, goes against the very fundamental of any lending transaction, like a banking transaction. Bank, my lord, must be having a right to, my lord, recall, my lord, in the event of default. Now, my lord, here, my lord, the payment is by quarterly installments. Well, in the event of default of any one installment payment, there are two rights. One, my lord, a higher rate of interest, my lord, will start operating. But, my lord, without prejudice to that, I showed you also the last occasion, that, my lord, there is a right to recall the entire loan. Now, if the argument of my learned friends have to be accepted, then the right given to a lender in the event of default, my lord, becomes a dead letter. Well, it's totally ineffective completely. Because that's, my lord, that is the submission here. Now, that with respect, my lord, cannot be, my lord, there in a financing transaction. Because if it's very, my lord, fundamental to a lender, my lord, then in the event of default, the lender, my lord, can get itself repaid. Now, my lord, look at the facts of this case here. 5th April, my lord, was the payment date of installment. By 28th of May, the default had not been cured. The next installment is due on 5th of July, which is a quarterly payment. So, my lord, on 28th of May, my lord, when repayment had not been made, payment had not been made, my lord, of the 5th April installment, a notice was given, my lord, to cure the default, giving 15 days time. And 15 days time, my lord, is very reasonable for the simple reason that it's a quarterly payment of installment. The next installment falls due on 5th of July. So 15 days, my lord, takes, my lord, the date to 13th or 14th of June. Within the 15 days, the default was not cured. So, my lord, what was the result? On 13th of June, my lord, the entire loan was recalled. Notice was given, my lord, to the borrower. And, my lord, Piramal filed an application under Section 7, my lord, of the IBC before the NCLT. These three things happened, my lord, between 13th and 18th of June. My lord, the documents are with your lordship.
Yes.
Now, my lord, the argument, my lord, is this. 18th of June, my lord, they paid, and apparently, my lord, default gets cured. Now, with respect, my lord, once the loan is recalled by Piramal, the contract comes to an end. Once, my lord, the contract comes to an end, my lord, it cannot be revived, my lord, by a cure unilaterally. In the sense, my lord, payment is being made. They can, my lord, any payment they make, will accept. 5th of July installment, my lord, must have been paid with some delay. We'll either keep on paying, we'll keep on accepting. But, my lord, with respect, once, my lord, the loan has been fully recalled, that cannot be, my lord, that, my lord, won't become a cure of the default, my lord, because I already acted on the default. Piramal has acted on the default, recalled the entire loan, and, my lord, moved the NCLT.
Yes.
So, my lord, these arguments, my lord, with respect, I submit as no relevance. Now, but nonetheless, my lord, the learned raised, my lord, this point. I have, my lord, I will show you lordship a Supreme Court judgment in this case. Well, my colleagues will give it to you, lordship. 2005, 11 SCC, page 73, at, my lord, page 97, paragraph 52. Can I request one of my colleagues to give it to you, lordship?
Yes.
Now, my lord, my learned friend's whole argument is time is not of the essence. Now, my lord, first submission, my lord, is there is a recall power given which we have acted on. That cannot be, my lord, wished away. Secondly, take, my lord, paragraph 52. If a time is stipulated, see, my lord, this is the law.
Yes.
If no time is fixed, my lord, is one thing. If some time is fixed, kindly now see paragraph 52. As there was no time fixed either under 57A or in the offer letter, the question of time being of the essence did not at all arise. As was held in Gomutinagam Pillai, stipulation must show the intention was to make the rights of parties depend on the observance of the time limits prescribed in a fashion which is unmistakable. Now, it is there in this case. Time. Then we'll see. There is no stipulation as to time. It was open to a party unilaterally stipulated time and then cancel the contract because of an alleged failure, other party to act in time. Of course, now see what is the important line. Of course, the time is fixed by the contract, but it is not originally of the essence. A party could, by notice, served upon the other, call upon him to complete the transaction in time fixed and intimate that in default of compliance with the requisition, contract treated as cancelled. This is the law. If some time is fixed and the time passes, it is open to the innocent party to give a fresh notice and make time of the essence.
Yes.
And this is exactly what has happened here. It is not a case, my lord, that there was no time at all. The time was fixed. Default, my lord, occurred. On 28th of May, my lord, default was still, my lord, subsisting. It is still there.
Yes.
On 28th of May, my lord, Piramal gives a notice, fixes a fresh date of, my lord, 2 weeks. And on expiry of the fixed date, my lord, they gave notice on the 13th of, on, my lord, 28th of May, that, my lord, if you do not pay that 15 crores, whatever the amount is, within, my lord, 2 weeks, we'll call up the entire loan. And on 13th of June, my lord, the entire loan was called up when the default was still subsisting.
Yes.
So, my lord, this is the law, my lord, which, my lord, and that 15 days, my submission is, my lord, reasonable. My lord, making payment on the 18th of June, my lord, does not cure that default because, my lord, Piramal has acted on the default already by calling up the entire loan on 13th of June and having filed, my lord, NCLT application.
Yes.
So, my lord, the judgments my learned friend have cited, lordship will see they're not a financing transaction at all. Those are all, my lord, sale of goods, my lord, and construction contract where time was not of the essence. And, my lord, the court said that time is not of the essence, therefore you cannot, my lord, do anything. Here, my lord, not only there was time fixed, originally, fresh notice was given, and, my lord, on the basis of that notice, my lord, action was taken. It's an option, my lord, given to the lender to recover the loan, my lord, and lordship, my lord, with respect, cannot, my lord, say that clause has no meaning. That if there's default, my lord, the entire loan can be called up, my lord, has no meaning at all. With respect, my lord, then the contract, my lord, will be a totally different contract. We'll not be rewriting the contract. Now, my lord, two other points I urged, my lord. They had, my lord, mentioned something about pledge, my lord, and mortgage. Now, my lord, the pledger and the mortgagor is not before lordship, my lord, seeking relief. Number one. Number two, lordship will see, my lord, my colleagues will give it to your lordship. Under the contract act section 176, kindly, my lord, look at section 176. Lordship will find, my lord, that a pledgee, my lord, must give notice before it can invoke a pledge.
Yes.
Now, my lord, it is nobody's case, my lord. In this case, notice of, my lord, invoke a pledge has been given.
Yes.
Pledger, my lord, has not moved your lordship because no notice has been given. If, my lord, by any chance notice has not been given all these days,
Yes.
my lord, if you were anxious, something will happen 1 day, 2 days, nothing has happened.
Yes.
If, my lord, a notice is being given by Piramal, my lord, the pledger will have a right to move, or the borrower will have a right to move. Today is premature. Number one. Now, the mortgage. I should have thought, my lord, age-old principle, my lord, unless you file a suit for mortgage under Order 34, no suit is maintainable. Kindly see, my lord, Order 34, Rule 14 of the Code of Civil Procedure. A mortgage suit has to be filed. In a suit like this, my lord, lender, my lord, cannot enforce a mortgage. Look at, my lord, Order 34, Rule 14.
Yes.
Kindly see, my lord, if a lender, even if he sues for a mortgage money, the loan, the mortgage can't be enforced without a fresh suit under Order 34.
Yes.
My lord, the reason is, my lord, because historically, my lord, a mortgagor has a right to redemption. And, my lord, without giving the mortgagor, my lord, a right to redemption, which is, my lord, protected under Section 6 of the Transfer of Property Act, is, my lord, 100 years old, my lord, hundreds of years old. Because, my lord, mortgagor is to, my lord, secure their residential dwelling to take money. So the law, my lord, protected mortgagor by giving an equity of redemption, which means mortgagor will always have a chance to redeem. And hence, my lord, a mortgage property, my lord, cannot be put up for sale without a mortgage suit, in which, my lord, the mortgagor will be a party who will have a right to redeeming the mortgage. So, my lord, today, my lord, these, my lord, arguments are in the air about pledge, my lord, risk of pledge, risk of mortgage. These things are not there at all today. I have to file a mortgage suit, my lord. Piramal has filed mortgage suit to enforce the mortgage. Piramal has to give a notice, my lord, to invoke pledge. People, my lord, they can proceed against the pledge property. The law is very clear. Now, my lord, I come, my lord, to jurisdiction point. My lord, it was not our submission, my lord, that your lordship has no jurisdiction to try the suit. My lord, submission was, my lord, that event of default, under the law as it now stands, only NCLT, my lord, can adjudicate that question because, my lord, Piramal is a financial credit under Section 7.
Yes.
And, my lord, I've given the law, I've given the section to your lordship. It
Yes.
is not, my lord, the submission that lordship can't take up the suit at all.
Yes.
Lordship examine, my lord, whether the lordship can get in the event of default, where, my lord, in my submission, view of the sections I've given to your lordship, NCLT, my lord, has, my lord, only jurisdiction is NCLT jurisdiction. And, my lord, if your lordship makes observations which, my lord, will affect the NCLT's pending proceeding, then, my lord, with respect, my lord, that will be without jurisdiction.
Okay.
So, now, my lord, I believe Mr. K.T. Thakkar, my lord, wants to add something about securities, my lord. I don't know whether he's there. My lord, before your lordship, my lord, if your lordship will permit him, my lord.
For the security trustee, my lord, to deal with Mr. Mukherjee's arguments that the loan has been recalled by the security trustee and not by the lender, and hence these recall notices are bad. But I've prepared a compilation just of the relevant clauses because the documents are voluminous.
Yes.
Kindly have, my lord, first.
But I'm sorry, my lord. Still one, my lord, lordship, my lord, with Mr. Thakkar's leave. The Indus Biotech case they have cited, my lord, I'm not followed the relevance of that case. Indus Biotech case, my lord, says that it, my lord, the NCLT proceeding become an action in rem, even admission is, my lord, made.
Yes.
It is not my submission action in rem today. I may not made the submission. I'm not concerned about action in rem. I'm not saying event of default, my lord, only NCLT can decide.
Okay.
And, my lord, in the Indus Biotech case, lordship will see matter went to arbitration, but, my lord, the NCLT gave a judgment on merits that there was no default.
Okay.
That's why, my lord, it could go to arbitration. I'm sorry, my lord, Mr. Thakkar, my lord.
Yes.
First, kindly have the loan agreement, my lord, the relevant sections of the clauses of the loan agreement. Kindly come to page 2, please, my lord. I want to show your lordship, my lord, that the security trustee has the obligation and duty under the loan agreement and the trustee agreement to recall the loan in the event of a default. Because Mr. Mukherjee's contention was that the loan could not have been recalled by the security trustee, only the lender could have recalled the loan. Kindly first see 12.1 at page 2. This is of the loan agreement to show your lordship, my lord, the interplay between the loan agreement and the trustee agreement.
Yes.
Until the discharge of all the secured obligations, the obliger shall be required to maintain the security as set out in the following schedules. Now, my lord, kindly see in favor of the lender or the security trustee. So, my lord, I am the security trustee. My role is this, like this, my lord. The securities are given to me and I hold it in trust for the lender. Now, my lord, so he has to maintain the securities in my favor. Then your lordship kindly turns to the next page, please, my lord. Then these informations are there. I'm not troubling your lordship with this. Kindly come to page where the security trustee agreement is. Kindly come to page 22, please, my lord. Where the security trustee agreement starts.
Yes.
This is the security trustee agreement.
Yes.
Now, my lord, kindly see recital B at page 23. Company, my lord, here is the borrower. The company hereby covenants that it shall create or cause the relevant obligers to create, as the case may be, the following security in the manner detailed in the loan agreement in favor of the security trustee. It's not in favor of the lender, it's in favor of the securities trustee to secure inter alia the loan on the terms and conditions set forth in the loan agreement and the security documents.
Yes.
So, my lord, the security is to be created in my favor. Then kindly come to the next page, please, my lord. Kindly see 2.3. Authority for certain actions. The lender hereby authorizes and directs, and the security trustee hereby agrees upon receipt of written instructions from the lender for the benefit of the lender. Then kindly omit the first few. Kindly see 2.3.4, because this is what was happening. Receive and disburse all monies in accordance with the finance documents. And I'll show your lordship the emails which they have disclosed. Monies used to be received by the security trustee. He would, in an escrow account, and he would instruct the lender who would withdraw the monies. Then, my lord, kindly see. Take whatever action that shall be required to be taken by the security trustee by the terms and provisions of this agreement and or the other finance documents to exercise its rights and perform its duties and obligations provided thereunder. So under both the agreements, my lord, I have rights. Then, subject to the terms and provisions of this agreement and the finance document, take such other action in connection with the foregoing as the lender may from time to time direct. Then kindly see 2.1.3 at page 25, duties and powers. 2.1.3.3 relates to, my lord, maintaining the securities. Then kindly come to the next page. 2.1.3b, to take all relevant actions and or refrain from taking, as the case may be, to preserve the rights and security interests constituted under the finance documents as and when necessary to do so, and to refrain from any act and avoid any omissions which may prejudice the value of the validity of the rights and the securities constituted on the finance documents, all in accordance with the terms and conditions of this agreement and the other finance documents. Other finance documents, my lord, being the loan agreement. Then kindly see the next. To enforce, kindly see, to enforce and foreclose the rights and security constituted by the finance documents, and to perform all such acts, deeds, and things which the security trustee may from time to time deem necessary or appropriate for or incidental to such enforcement and foreclosure of the rights and security constituted by the finance documents, all in accordance with the terms and conditions of this agreement and other finance documents. So the widest powers are given. Then kindly come to the next page, please, my lord, 310. Duties and powers of the security trustee. Page 27. Page 27. Running page 27, my lord. The handwritten number. Yes. Page 27. Kindly see clause 5. Duties and powers of the security trustee.
Yes.
In the event the security trustee has knowledge of any event of default, kindly see.
Yes.
It is my duty. The security trustee shall give prompt telephonic or electronic notice followed by prompt written notice by courier thereof to the lender. I have to inform the lender that there is an event of default.
Correct.
Upon the security trustee having given to the lender a written notice of any such event of default, the security trustee shall await written instructions as provided in clause 5.2 below, and kindly see, and act in accordance with such written instructions.
Correct.
The security trustee shall neither take any action nor shall be under a duty, not have any liability for its failure to refusal or to take or refrain with respect thereto if it does not receive the written instructions as provided herein. So I will take action only once the lender says there's an event of default. I inform the lender gives me instructions, I act. Then kindly see 5.2. Subject to the terms and provisions of clause 5.1 above and the provisions of the finance documents, the security trustee shall, upon the written instructions of the lender, take or refrain from taking any action or actions, including taking steps to enforce the security, not inconsistent with the terms and provisions of the finance document or applicable law as may be specified in such instructions. The security trustee shall, during the subsistence of this agreement and the other finance document, exercise all its powers, authorities, and discretions, kindly see, for the benefit, protection, and interest of the lender, and shall not do any act or thing which is prejudicial or detrimental to the interest of the lender. Notwithstanding anything contained in this agreement, the security trustee at all times before taking any action in terms of powers granted under this agreement and the other finance documents take a written approval from the lender and act accordingly. So, my lord, I have to intimate the lender of the notice of default. On instructions of the lender, my lord, I have to act. Now, my lord, kindly come to the next page. These are the communications. Kindly see, my lord, after the event of default. Kindly come first to, my lord, page 34. Yes, Supriyo. So this is, my lord, the lender writing to me. This has reference to the discussion held with Yash, wherein it has been decided to initiate legal enforcement for all the credit facilities extended to the money group. Please find below overall status of the Piramal credit facilities. Primarily, we would like to initiate enforcement against money group only, and at later stages, we can invoke the Salarpuria group. Request your view strategy to take this forward. Page 34. So this is, my lord.
So this is written by whom?
This is by the lender to the trustee. Yes, this is a new document. This is a new document. No, this is internal communication between the lender and the security trustee. Because an objection has been taken that the security trustee could not have recalled the loan. The documents, the loan agreement and the security agreement provide that the security trustee will inform the event of default and take accordance with the lender, directions of the lender. Then, Mother, kindly see.
Let's give another copy.
Page 33.
I'm appearing for a dependent and
Page 33, Your Lordship will kindly see. We are in the process of drafting. I'm sorry, my lord. Page 33.
Yes.
doesn't mean next.
We are in the process of drafting the recall notice. In view of the fact that we want to enforce for the full amount basis the attached, we request you to share with us all relevant documents pertaining to the facilities.
Yes.
So, my lord, these are the instructions basis which, my lord, the notice was recalled. The loan was recalled. So, the security trustee, under the terms of the document, had the full right and authority, my lord, to act on the instructions of the lender and to recall the loan, which it has done.
Yes.
Now, my lord, apropos why the security trustee was given this authority, your lordship will find from the emails, my lord, kindly have. Because it was on the security trustees instructions, my lord, that the monies were withdrawn. Kindly have, my lord, volume 4, please.
Yes.
Kindly have, my lord, page 577, please. So here, my lord, the monies, please issue the following FT transaction. The money is a credit account. Kindly see Piramal Finance Limited. So the security trustee is writing to the team, my lord, that is R2 writing to R1, that please issue the instructions to credit the account of Piramal Finance and debit the account of Money Reality.
Yes.
So that is the role, my lord, which the security trustee pays. Your lordship will also find in 580. All payments, my lord, are routed through the security trustee. The lender does not receive any payment without the security trustee.
580.
580, please, my lord. Kindly see, it is from Piramal Trustee.
Yes.
Writing to the escrow account of HDFC Bank, dear escrow team, kindly process the attached front transfer instructions and confirm once done. So, my lord, it is the security trustee which directs payment of funds to the lender. That is how the agreement is to be worked out. So that is the role which the security trustee plays. And it is fully competent, my lord, to issue the loan recall notices.
Yes.
Now, if your lordship kindly takes Indus Biotech ones, please, ma'am. Indus Biotech was handed over to your lordship, my lord. এইখানে আছে। জজসাহেবের কাছে আছে। Indus Biotech, my lord, as Mr. Sarkar pointed out, actually supports my case, my lord. It gives exclusive jurisdiction to the tribunal. Kindly see page 444, please, once, my lord.
Yes.
This Supreme Court, my lord, was considering an arbitration petition filed by Indus Biotech Limited under section 11.3 read with section 11.4a and 11.12a of the Arbitration Act, because, my lord, certain entities were foreign entities.
Where from you are reading?
Page paragraph 2 at page 444.
Yes.
So, my lord, here the Supreme Court was considering a section 11 application
Yes.
filed for appointment of an arbitrator. Now kindly come to, my lord, 449.
Yes.
Now, my lord, what has happened in this case was, my lord, in a section 7 application filed by the financial creditor, a section 8 application was filed by the corporate debtor. The adjudicating authority, that is the NCLT, my lord, decided the section 7 application, and along with it decided the section 8 application and stayed the proceeding. That is what now the Supreme Court considers as to what is how the adjudicating authority is to decide if... Yes, kindly see, my lord. Paragraph 17. Dr. Singhvi, my lord, appeared for the financial creditor. 16, his arguments are noted. Then kindly come to 17. The procedure contemplated will indicate that before the adjudicating authority is satisfied as to whether the default has occurred or not, in addition to the material placed by the financial creditor, the corporate debtor is entitled to point out that the default has not occurred and the debt is not due. And you see paragraph 17. This is what, Malad, they beseech your lordship to decide. Consequently, to satisfy the adjudicating authority that there is no default, he has an opportunity before the tribunal. In such exercise undertaken by the adjudicating authority, if it is found that there is default, the process as contemplated under subsection 5 of section 7 of the code is to be followed as provided under subsection 5A. Or if there is no default, the adjudicating authority shall reject the application as provided under section 5B to section 7. In that circumstances, if the finding of default is recorded and the adjudicating authority proceeds to admit the application, the CIRP process commences as provided under subsection 3 and 6 and is required to be proceeded further. In such event, it becomes a proceeding in rem on the date of admission, and from that point time onwards, the matter would not be arbitrable. So, my lord, what I am trying to stress on is that it is not that merely because an application is filed, they do not have an opportunity to raise their grievances that there is no debt and default. The adjudicating authority will decide this. Now, kindly come to paragraph 21. In such circumstances, if the adjudicating authority finds from the material available on record that the situation is not yet ripe to call it a default, that too if it is satisfied that it is a profit-making company and certain other factors which require which need consideration, appropriate orders in that regard would be made. The consequence of which could be the dismissal of the petition under section 7 on taking note of the stance of the corporate debtor. As otherwise, if in every case where there is debt, if default is also assumed and the process becomes automatic, a company which is ably running its administration and discharging its debts in planned manner may also be pushed to the corporate insolvency resolution process and may get entangled in a proceeding with no point of return. Therefore, the adjudicating authority certainly would make an objective assessment of the whole situation before coming to the conclusion as to whether section 7 of the IB code is to be admitted in the factual background. Dr. Singhvi Malad, who appeared for the financial creditor, however, contended that when it is shown that the debt is due and the same has not been paid, the adjudicating authority should record default and admit the petition. He contends that even in such a situation, the interest of the corporate debtor is not jeopardized inasmuch as the admission orders made by the adjudicating authority are appealable to the NCLAT and thereafter the Supreme Court, and where the correctness of the order in any case could be tested. We note it cannot be in dispute that so would be the case even if the adjudicating authority takes a view that the petition is not ripe to be entertained or does not constitute all the ingredients, more particularly default, to admit the petition, since even such order would remain appealable to the NCLAT and the Supreme Court, where the correctness in that regard will also be examined. So there is adequate remedy provided under the Act. Then, my lord, kindly turn to paragraph 27. The, my lord, primacy given to the IBC even over and above the Arbitration Act. Kindly see 27. As noted above, which is the situation today, my lord, As noted above, the issue which is posed for our consideration is arising in a petition filed under Section 7 of the Code before it is admitted, and therefore not yet an action in rem. In such application, now kindly see, the course to be adopted by the adjudicating authority if an application under Section 8 of the Act is filed seeking reference to arbitration is what requires consideration. Kindly see, the position of law that the IB Code shall override all other laws as provided under Section 238 of the IB Code needs no elaboration. In that view, notwithstanding the fact that the alleged corporate debtor filed an application under Section 8 of the Act, the independent consideration of the same dehors the application filed under 7 and materials produced therewith will not arise. The adjudicating authority is duty bound to advert to the material available before him as made available along with the application under Section 7 of the IB Code by the financial creditor to indicate default along with the version of the corporate debtor. This is for the reason that keeping in perspective the scope of the proceedings under the IB Code and there being a timeline for the consideration to be made by the adjudicating authority, the process cannot be defeated by a corporate debtor by raising moonshine defense only to delay the process. In that view, even if an application under Section 8 of the 96 Act is filed, the adjudicating authority has a duty to advert to the contentions put forth on the application filed under Section 7 of the Code, examine the material placed before it by the financial creditor, and record a satisfaction as to whether there is a default or not. While doing so, the contention put forth by the corporate debtor shall also be noted to determine as to whether there is substance in the defense and to arrive at the conclusion whether there is default. If the irresistible conclusion by the adjudicating authority is that there is default and the debt is payable, the bogey of arbitration to delay the process would not arise, despite the position that the agreement between the parties indisputably contains an arbitration clause. So, this, with the greatest of respect, this proceeding is a bogey. Whatever defenses they urge over here, time not being of the essence, there is no debt, there is no default, you have waived default, you could not have recalled the loan after you've taken interest. All these are defenses which have to be adjudicated by the adjudicating authority first before declaring there's a debt and default. They would have an opportunity, and this can be challenged right up to the Supreme Court.
Yes.
So, and that is why, the Supreme Court here holds that even if you file a Section 8, that does not mean that you cannot, that the court will be tied down. Kindly see paragraph 29 once, please, my lord. Therefore, to sum up the procedure, it is clarified that in any proceeding which is pending before the adjudicating authority under Section 7 of the Code, if such petition is admitted upon the adjudicating authority recording the satisfaction with regard to the default and the debt being due from the corporate debtor, any application under Section 8 made thereafter will not be maintainable. So we are not at this stage, now we are at the stage before this. In a situation where a petition under Section 7 of the Code is yet to be admitted, and in such proceedings, if an application under Section 8 of the Act is filed, the adjudicating authority kindly is duty bound to first decide the application under Section 7 of the Code by recording a satisfaction with regard to there being default or not, even if the application under Section 8 of the 96 Act is kept along for consideration. In such event, the natural consequence of the consideration made therein on Section 7 of the IB Code application would befall on the application under Section 8. Similarly, if the adjudicating authority, while considering the Section 7, is satisfied that there is a debt and default, it will not proceed to touch the Section 8 application. But if it is satisfied from the documents disclosed in the Section 7 and the defense which is taken out by the corporate debtor, then it will hear the 7, find that there is no default, and refer the parties to arbitration to determine whether there is a debt and default. Okay. Now, what my learned friends want to do, my lord, is to put the cart before the horse by filing this suit. This is exactly what the Supreme Court says is not permissible. 7 takes primacy over everything else, even if there's an arbitration agreement between the parties.
Okay.
So, my lord, with the greatest of respect, Indus Biotech actually, my lord, very clearly lays down what the law is. Then, my lord, your lordship's decision, my lord, kindly see the once the reliefs claim, my lord, in the plaint once, please, my lord. Kindly see the reliefs once in the plaint. page 57. It was argued that these are prayers in the nature of declaration and injunction, therefore they are not barred.
Yes.
Kindly see, my lord. Yes. Decree. Kindly see page 57, paragraph 98. A decree declaring that the letter dated so-and-so is void, illegal and non-est. A decree declaring that the letters dated so-and-so are void, illegal and non-est. A decree declaring that the letters dated so-and-so are void, illegal and non-est. So 4 letters issued by me, which include the loan recall notices, are void, illegal and non-est. Yes. Greatest of respect, this is what is to be adjudicated by the adjudicating authority to determine whether there is a default.
Yes.
Because if these letters are bad, then there is no question of default.
Yes.
Then, my lord, kindly see. A decree of perpetual injunction restraining the respondent from so-and-so acting in pursuance of or giving any further effect to the purported notices dated so-and-so. The perpetual injunction restraining me from giving any effect to these notices. The effect of this would be to denude the NCLT of jurisdiction whether there's a default or not, because I would rely on these very letters to establish that I have recalled the loan, he has not paid, therefore there's a default. Then, my lord, kindly see, then there's a claim for monetary damages. These cannot, as Mr. Shorkar fairly submitted, whatever there is, your lordships will determine whether the case for damages, etc., will continue or not. Okay. But there is no case made out for declaration injunction. Recently, my lord, your lordship has held in the HON'BLE matter that reliefs paying for injunctions on letters, etc., your lordship has passed a decree, are squarely barred. This is a decree which your lordship has passed. If there's no question of a final decree, the question of granting an interim relief, here also the prayers, CDE were injunction restraining me from writing any letters, taking on the action any basis, is squarely barred, my lord.
Yes.
Now, my lord, one clause of the contract, if your lordship will kindly see once, please, my lord, of the loan agreement. These are, my lord, parties who have entered into a transaction at arm's length, there is no case of coercion, etc. made out. Knowing fully well they've entered into a transaction, now, my lord, can they seek to rewrite a clause of a contract? That is, my lord, the point here. Kindly come to clause 17, please, my lord, consequence of event of default. My lord, petition volume 2. Petition volume 2 or the compilation also is there.
You given in the compilation?
Yes. Kindly give me a minute, my lord.
Compilation page 6, lordship.
Yes.
Starts at page 6, Mr. Thakur says page 7.
Page 6, your lordship will have consequences of an event of default.
Yes.
This was shown to your lordship. I just want to show your lordship. On the occurrence of an event of default, lender may in that event have the rights described hereunder and the rights available under the applicable law as well as under security document created in accordance with these terms and conditions. Kindly see, cancel or terminate any available commitment, declare that all or part of the loan, together with interest accrued and all other amounts accrued, be immediately due and payable, whereupon they shall become immediately due and payable. This is a specific right granted to me on the event of a default. It is nobody's case, my lord, that there is no default. Their case is default has been remedied. But this is, my lord, an overriding right which is given to me. And kindly see 17.1.0 at the bottom of page 174.
Yes. In addition to
yes. In addition to the above, so long as the event of default continues, the borrower shall pay default interest on the defaulted amount. So his default was continuing from the date of occurrence. This is a continuing obligation on his part, my lord, until such event of default are rectified and final payment in respect thereof made to the lender. Then kindly see, very important, without any prejudice to the remedies available to the lender or the consequences of event or default. Page 175 top, please, my lord. So the fact that he even remedies the default.
No, I think pages are missing here.
I'm sorry.
17.5, 17.1.0. Then it has come.
Kindly see page. Yes, one. I'm sorry, my lord. 88 about 100. Kindly have the petition. I'm sorry, my lord. Kindly have volume 2 of the petition, pages 88, 89.
Page 188.
Page 88, 174, please, my lord.
Yes. Yes, you have shown that.
My lord, just 1 minute, I'm sorry to repeat. My lord. In addition to the above, so my lord, this is in addition to the rights given above, so long as the event of default continues, the borrower shall pay default interest, which is the agreed rate of interest, on the defaulted amount from the date of occurrence of the event of default herein above until such event of default is or are rectified and final payment in respect thereof made to the lender. So he has to anyway rectify the default, then, but that does not take away my right. Kindly see, without any prejudice to the remedies available to the lender on the consequences of event of default. So merely because, my lord, he rectifies the default on a subsequent date does not, my lord, impair the right which is vested in me to recall the entire loan. It's a clear clause, my lord. It's without prejudice to all rights that I have. And this, my lord, may I just show your lordship one decision of the Supreme Court, please, my lord. Kindly see page 1964 FCC online SC 239. And see clause 10. Clause 10 on the first page.
Yes.
Kindly see the clause there. The insurance was subjected to various conditions and stipulations printed in the policy, of which clause 10 was on the following terms. The insurance may be terminated at any time at the request of the insured, in which case the company will retain the customary short period rate for the time the policy has been forced. Next is very important. This insurance may also at any time be terminated at the option of the company or notice to that effect being given to the insured, in which case the company shall be liable to repay on demand a rateable proportion on the period for the unexpired term from the date of the cancellation. Now, my lord, kindly see. The insurance company, my lord, in this case, terminated. Kindly see the next page, please, my lord. Last but one paragraph. The main question in this appeal is whether the policy had been terminated. The respondent contends that it had the power under clause 10, that is the insurance company, my lord, had the power under clause 10 of the policy to terminate the contract at will, and it had duly exercised the power by the letter of 7th August 47. The appellant denies both these contentions. It states that the term must be implied in clause 10 that the termination could only be for a reasonable cause, which the termination in the present case was for naught. It then said that the rules of interpretation, now kindly see, it then said that the rules of interpretation do not permit of the term being suggested being implied. Clause 10 must be treated as void and ignored. The contention of the appellant is based on the interpretation of clause 10. Now kindly see, now it is commonplace that it is the court's duty to give effect to the bargain of the parties according to the intention. And when that bargain is in writing, the intention is to be looked for in the words used, unless they are such that one may suspect that they do not convey the intention correctly. If those words are clear, there is very little that the court has to do. The court must give effect to the plain meaning of the words, however it may dislike the result. We have earlier set out clause 10 and we find no difficulty or doubt as to the meaning of the language there used. Indeed, the language is the plainest. The clause says the insurance may be terminated at any time at the request of the insured, and the insurance may also at any time be terminated at the instance of the company. These are all the words of the clause that matter for the present purpose. The words at any time can only mean at any time the party concerned likes. Shortly put, clause 10 says either party may at its will terminate the policy. No other meaning of the words used is conceivable. Similarly, the language of the clause is clear. There is no scope for interpretation, and the court must give effect to the clause. And therefore, my lord, all the arguments were concerned, and the court held that no, the policy stands terminated.
Yes.
The appeal was dismissed. Your lordship will see on the last page. The last page, my lord, the appeal on the insurance claim was dismissed. It says policy was rightly terminated and you are not entitled to any claim on the insurance which was made after the date of termination. These are my responses.
Thank you.
My lord, I'll take 5 minutes. If your lordship, my lord, permits it.
Complete, Mr. Mukherjee.
Yes. Now, my lord, kindly, my lord, only one case. My lord, I will distinguish the rest. My lord, we are now, my lord, going into too much in this matter, my lord, according to me. My lord, Claude Leela Parulekar's case, my lord, 2005, 11 Supreme Court cases, 73. That was the case Mr. Sarkar cited, my lord.
Yes.
My lord, kindly have a look at, my lord, what was an issue, my lord, was whether, my lord, there had been a repudiation of a contract to purchase, my lord, shares, my lord, which are movable, my lord, and my lord, goods, my lord, within the meaning of the Sale of Goods Act. Now, my lord, apropos that, the question had arisen, my lord, where, my lord, time is of the essence or not. Kindly, my lord, come to, my lord, para 50. My lord, my learned friend relied on para 52. My lord, kindly have a look at, my lord, para 50. This is how the question, my lord, arose. Kindly have a look. We are of the view that there was also no repudiation of the contract by the appellants as contended by the respondents on account of the appellant's alleged failure to pay the price within the time fixed by the respondent numbers 2, 3 and 4 by their notices dated 21st February 85. Section 11 of the Sale of Goods Act expressly says, Lord, kindly see, unless a different intention appears from the terms of the contract, stipulations as to time of payment are not deemed to be of the essence of a contract of sale. Whether any other stipulation as to time is the essence of the contract or not depends on the terms of the contract. So time, my lord, for sale of goods, if it is mentioned also, is not of the essence. Now, my lord, kindly see para 52. And my lord, this entire paragraph, my lord, is in the context of sale and purchase of goods. My lord, I'll show your lordship. As there was no time fixed either under Article 57A or in the offer letters, the question of time being of the essence did not at all arise. It's because there's no time fixed. As was held in Gomanthiagan Pillai versus so-and-so, stipulation must show that the intention was to make the rights of the parties depend on the observance of the time limits prescribed in a fashion which is unmistakable. My lord, this was, my lord, an immovable property case. My lord, there also, my lord, time is not of the essence. Now, my lord, if there is no stipulation as to time, it is not open to a party to unilaterally stipulate a time and then cancel the contract because of an alleged failure of the other party to act within the time stipulated. Now, my lord, what is relied on, my lord, is, my lord, National Cooperative Sugar Mills versus Albert and Company. This is again, my lord, a decision of the Madras High Court on, my lord, Section 11 of the Sale of Goods Act. Of course, if time is fixed by the contract, but it is not originally of the essence, a party could, by notice served upon the other part, call upon him to complete the transaction within the time fixed and intimate that in default of compliance with requisition, contract will be treated as cancelled. This is, my lord, repudiation, my lord, of a contract relating to sale of goods. It's got nothing to do, my lord, with, my lord, this case has nothing to do, my lord, with financing transaction. And this, my lord, principle, proposition, my lord, in paragraph 52 is also in relation to, my lord, sale and purchase of goods. But when no, and this is clear from the next sentence, but when no time is fixed for completion, it is not open to either the, kindly note, vendor or purchaser to serve notice limiting a time at the expiration of which he will treat the, in the circumstances, the contract for sale of goods could not have been avoided. My lord, vendor, purchaser, where does it all appear in a financing contract? My lord, this is solely, my lord, in, my lord, in the context of sale and purchase of goods. Now, my lord, my learned friend, my lord, handed up a bunch of documents to your lordship. আমাকে কপি দাও তো এখান থেকে সুবিধা হবে না My lord, I'm grateful, my lord, he's given me a soft copy, but unfortunately that's not paginated. So, my lord, I will, my lord. Now, my lord, most important thing, my lord, kindly take, my lord, the petition, my lord, the loan agreement, my lord, which is, my lord, in volume 1, page, my lord, kindly come to, my lord, clause, my lord, 17. My lord, it starts at 156, clause 17 is, my lord, it starts, I've got it here. My lord, starts at, my lord, page what? 173. Now, my lord, kindly come to page, my lord. My lord, page 174. Kindly come to page 174, which your lordship just opened. My lord, what did I rely on? My lord, I said, my lord, that, my lord, under the loan agreement, the only person who can declare, my lord, a sum due and issue the my lord, the recall notice, my lord, is the lender. Kindly see this.
Declare.
Declare that all or part of the loan together with accrued interest and all other amounts accrued or outstanding under the finance documents be immediately due and payable, whereupon they shall become immediate. So this declaration has to be made to me. So, my lord, it is only the lender. My lord, there is no question of anybody else doing it. Now, my lord, both, my lord, 28th of May and, my lord, the letter of, my lord, June, my lord, which, my lord, my compilation, your lordship will find 13th of June and, my lord, 28th of May are issued by, my lord, the trustee.
Yes.
Both of them. My lord, those are, my lord, at page, my lord, 12 and, my lord, at page, my lord, 20. Both are, my lord, by, my lord, the trustee. And, my lord, they actually say that the recall letter is of 28th of May, not any other document. So, my lord, he could not have. Now, what is their answer to this? My lord, they take your lordships, my lord, through, my lord, some, my lord, clauses of the loan agreement and, my lord, the security, my lord, agreement. My lord, not one of them says that the declaration, my lord, can be, my lord, be made, my lord, by, my lord, the security trustee. Now, what do the clauses, my lord, say? The clauses say, my lord, that, my lord, upon written instructions, my lord, they can, my lord, do whatever the lender asks them to do. So they said, my lord, these correspondence show that the lender authorized me to issue a recall notice.
That is the case.
Yes. Now, kindly have a look at these letters, my lord. They are, my lord, telltale. Kindly come to page 28, my lord. I believe your lordship's copy, my lord, would be paginated.
Yes.
Kindly have a look. My lord, page 28, it starts. It's from Sabera Agarwal. Now, kindly note, Sabera Agarwal at piramal.com.
Yes.
My lord, this is of Piramal Finance, respond number 1.
Yes.
So, my lord, subject is this from Sabera Agarwal, 28 May 2022. First mail, my lord, goes to Piramal trustee. Now, what does the mail say? Dear team, please find attached recall notice and TDS notice for Money Group. Request you to please issue the same to the client urgently. So there's a request to, my lord, issue. My lord, there has to be, my lord, a recall notice. Now kindly see, Deboshri De, my lord, who is, my lord, also, my lord, Piramal, my lord, and who has copied this mail. Yes, my lord, your lordship will find, my lord, the last line above subject, Deboshri De. Now, my lord, Deboshri De, my lord, writes, my lord, on the same day, my lord, kindly see, my lord, to Sabera Agarwal, etc., etc.
Correct.
My lord, this is how, my lord, this, my lord, mail, my lord, goes. Now, my lord, dear Sabera, please find attached the revised draft with some changes for your perusal and further action. Now, my lord, 27th May, my lord, I'm going backwards. That's how they've annexed it. Kindly come to, my lord. This is, my lord, issued. Dear Deboshri, please find attached final draft for issuance. We will incorporate exposure numbers tomorrow. Kindly confirm. 6th May, my lord, is, my lord, Sabera. We await your comments on draft note and update, etc., etc. And, my lord, it goes, my lord, back that way, right up to, my lord, page, my lord, 34.
24th April.
24th of April. So that is where, my lord, it starts.
Correct.
Now, my lord, none of these, other than, my lord, the, my lord, one, my lord, which has been shown, my lord, on 28th of May, my lord, relate to, my lord, my lord, a communication to Piramal trustees. Now, my lord, 34, kindly have a look.
Yes.
I'm sure the plaintiffs will have a lot to say. My lord, after the table, kindly see. Primarily, we would like to initiate enforcement against
Money group
only, and at later stages, we can involve Salapuria. This is the one with whom there is a dispute. The cat is out of the bag. I protect Salapuria. I get everything out from money, and if I get it out, why do I can reward Salapuria with the rest of the mall.
Okay.
And my lord, my respectful submission is the clauses, my lord, which they relied on, the clauses, my lord, which they relied on, do not authorize them, my lord, to declare that this sum is due and payable. My lord, they do not. And if your lordship sees, my lord, the clauses which they relied on, my lord, which is, my lord, the security trustee agreement, kindly come to page 23, my lord, of that compilation. My lord, first, my lord, is, my lord, recital, my lord, doesn't have any authorization. Now, my lord, authority for certain actions. Kindly have a look. The lender hereby authorizes and directs, and the security trustee hereby agrees upon receipt of written instructions from the lender for the benefit of the lender. My lord, kindly see, to receive and disburse all monies. This is not issued. Then, my lord, take whatever action as shall be requested to be taken by the security trustee by the terms and provisions of this agreement and or the other finance agreement to exercise its rights and perform its duties and obligations provided thereunder. Then, my lord, next, subject to the terms and provisions of this agreement and take such other action in connection with the foregoing as the lender may from time to time direct.
Yes.
Now, my lord, these are, my lord, form, my lord. This has got nothing to do with declaring, my lord, what amount, my lord, is payable. Then, my lord, kindly come to duties and powers. My lord, page 25.
Yes.
The security trust, my lord, 2.13.3, security trustee shall have the authority, inter alia, my lord, kindly see, my lord, A, B, C. None of them, my lord, is, my lord, relating to, my lord, declaring and then, my lord, taking, my lord, steps. And, my lord, kindly now come to, my lord, page 27, 5.1. In the event the security trustee has knowledge of any event of default,
Mr. Mukherjee, what about the B?
My lord,
2.1.
clause B, to take all relevant actions for refrain from taking any, as the case may be, to preserve the rights and security interests constituted under the finance agreement as and when necessary to do so, and to refrain from any acts and avoid any omissions which might prejudice the value or validity of so and so constituted, all in accordance with the terms and conditions of this agreement. This is, my lord, refraining from action so that security, my lord, is not impaired. My lord, what are the steps, my lord, they are to take? My lord, nothing there, my lord, to authorizing them, my lord, to declare, my lord, that this has become, my lord, payable. That has to be a decision communicated to me, my lord, by, my lord, the, my lord, finance company. None of these, my lord, thereafter apply.
Yes.
I have to be, my lord, first, my lord, before a recall notice is issued, my lord, I have to be told, my lord, that the entire amount has become due and payable.
Okay.
My lord, that by, my lord, the finance company. Because wherever they are writing on behalf of the finance company, your lordship will find, my lord, in my list of, my lord, documents, my lord, your lordship will find, my lord, they say so. Which means, my lord, that it is a demand by the finance company. Yes. Kindly, my lord, come to, my lord, page, my lord, 3 to 6. My lord, at page 5, my lord, kindly see.
Yes.
My lord, this is being issued without any pressure of any on part of the lender, security trustee and its officers for and on behalf of Piramal, earlier known as so-and-so, authorized signatory. Then, my lord, kindly come to
7.
Yes, my lord, page 7 at 8. Kindly see, my lord.
Signatory.
Yes.
That's your point out.
Yes. So, my lord, this is, my lord, that communication of declaration that's, my lord, the recall, or, my lord, the declaration that has to be communicated to me first. It has never happened.
Yes.
My lord, on, my lord, the reliefs, etc., my lord, I think my learned friends, my lord.
Thank you.
Your Lordship will, my lord, give me a little time also. I know, my lord, it's much beyond, my lord, 1:15. Well, I can come on Monday, my lord, if your lordship gives me a few minutes.
Monday.
The Tuesday, if possible.
Let's come on Tuesday.
Yes, yes, madam.
Counsel for the defendant number 1 and 2 have concluded the argument. Defendant number 1, 2, and 3 have concluded their argument. Counsel for the plaintiff prays for time to give reply. Let the matter appear on 12th August.
Very grateful.
Lordship, one humble intent, Lordship. Item number 2, your Lordship, today. Item number 2, Lordship, Krishna Thakkar has been appearing for the plaintiff. That, Lordship, I under some confusion, a wrong recording has gone down, Lordship, that 11 vacating application filed on behalf of respondent number 11 and 12, Lordship. That no vacating has been filed by 11 and 12, your Lordship. A wrong recording might go down, your
Gentleman who appeared,
there's some confusion.
it was not for 11 and
That's why he's telling.
Lordship, we have tried to assist, but Mr. Upadhyay started talking.
No, my Mr.
Okay,
Chaudhary.
come on, that they will see. That's why on 20th, let me clarify who has filed that.
I have kindly to take leave for filing the subpoena application, because the department is saying that they would not be able to.
In which subpoena?
The Purti matter, on 5th, your lordship had passed an order directing us to file an application. Calling for the CFSL person, Calcutta person to depose before the commissioner. The matter is due to appear on 11th, your lordship, for this application, but I'm seeking leave to file this application before the department.
What application you want to file?
Subpoena application, your lordship.
For issuance of subpoena.
Issuance of
So
subpoena.
file in the department.
But it's not accepting because it's not in order, your lordship.
What?
On the last occasion, the director of CFSL Bhopal had also been called in similar application, and my lord had given me leave, your lordship. So kindly give me leave to call the person.
Leave is granted to file in the department.
Well, may I have your lordship's leave?
Yeah. क्या मोटिव है कोई मोटिव है इसमें
Well, may I have your lordship's leave, to mention item number 44 of your lordship's list today. The doors matter, against State Bank of India. Mentioning upon notice, my learned friend is here. The interim order that was passed and extended time to time, it's due to expire today. Today is the last day.
Okay, comment. अच्छा हुआ है ना? Comment after. At the time of rising of the foot, I will take it.
Statesman versus Merlin. It was mentioned by them and kept on Monday at 3 p.m. I was saying, well, if it can be on Tuesday, Monday I have some difficulty. Tuesday same time if it's possible.
Lordship, 3 p.m. is not.
Or any time on Tuesday. Any time on Tuesday.
Lordship, normally I would not have objected to my learned senior friend, but Lordship, I am under specific instructions for my client. Lordship, there is great urgency in this matter, and that is why Lordship.
Monday and Tuesday, if it can be.
No, Tuesday there time hai.
First.
Tuesday there is no time. All matter fixed. That's in that 3 p.m. I got that. You are appearing for whom?
The first defendant, Berlin. The Chaudhary is the junior. He's also not here on Monday. He shouldn't have agreed because he's not here. And I will have a matter fixed before a matter 4. So that's why. That's anytime if it is possible.
Who is for the plaintiff?
Lordship, I am for the plaintiff.
I will do one thing. Let they complete. Your colleagues will be there. They take note of it. Let they complete, and I'll fix as per if any get any space in the list, then I will fix that.
I'm great.
My lord, item number 1. Now, my lord, I am to begin.
Lordship,
remember this was fixed, my lord, yesterday at 12:30.
Yes.
This was the matter which was again fixed yesterday at 12:30, my lord.
Which one?
Lord, this is the matter Mr. Bose is leading me for the plaintiff. He had completed.
That one?
Yes. Now, my lord, the only difficulty I have today is that there is only one day the special bench, concrete special bench which sits at 2 p.m.
Today?
Yes. Now, my lord, I have to be there. That's item number 1 there. So any day, my lord, he has taken 3 days. I'll only take 10 minutes. 10 minutes by the clock.
Come next week?
Any
Next
day,
Friday?
Lordship, any day Lordship gives me.
Next Friday?
Next Friday. What is
As item number 1?
It's
Oh, Friday is the 15th August.
Next Friday is
15th August.
15th August.
Then
Or 14th August?
because I am taking the non-commercial every Friday, and if I fix and because I am not having any space to fix any specific time before September. Friday every time from Friday.
22nd. 22nd.
22nd. I record an order. As per prayer. As per prayer made by the counsel for the defendant, let the matter appear on 22nd August at the top.
22nd
Under the same heading.
2 p.m. my lord. 2 Top p.m. 22nd or 29th? I'm very sorry, my lord. One day only it sits, my lord. Deeply obliged.
Get it.
Yes. Going to get respondent.
Defendant.
Well, this is my application inter alia for order 7 rule 11 for rejection of the plaint, where my learned friends on the other side is already concluded. I am in reply.
You are appearing for the plaintiff.
Sorry, Malad.
You are for the plaintiff.
Defendant.
Defend number?
Defend number 2, order 7, rule 11, Malad.
You filed.
2. Yes, Malad. Order 7, rule 11, but Malad, a point of order 7, rule 10 will also accrue here, Malad, because it is an attempt for return of possession on the basis of notice under Transfer Property Act or of a petrol pump, which is commercial in nature. So that would be the first thing. As a matter of fact, my learned friends were also required to take instructions where they would like to go to the commercial bench or not, but they have said no. They have said no, they can proceed in this. So,
you have taken instruction.
My lord, I am led by my senior, Mr. Shorshich Dasgupta. I am yet to hear from him. But
yet to hear from him. And then I'll argue that much, or should I wait for the next day? I don't know. I don't know what to do now.
Now, if you have taken instruction, then because petrol pump.
Because Malad, they have on the last statement, I wasn't able to be here, Malad. My learned junior was here. They have said that no, it's a commercial. It's not a commercial suit. So they've argued on that terms.
করবো করবো আজকে নাকি পরের দিন
Say
করবো?
করবো because the order says.
Let me then. Well, first things first, well, the plane.
Persons, before coming to the court, you are not going to the earlier
My
order.
lord, my lord, my
Every
apologies.
time new advocates are coming, my senior is there, and what's the last date? That's why the
My lord, my sincere apologies.
no, not your sincere. I am telling to the bar. One day, one junior is coming with senior. Second day, the senior is telling that I am busy. The other senior, I have no instructions. If tomorrow, if your senior will come, yes, let it go to the what will happen to this time which has the court consumed for hearing the parties? Already, this court is having a shortage of time. Yes.
So, Malad will kindly straight away come to the plaint, Malad, once. On page 25 of my application, Malad. Para 2 is part of the plaint. Partnership concerns dealer under the defendant number 1 is running the petrol pump at the suit property. Malad, this much itself, Malad, makes it a commercial property, Malad, and Malad, on that ground, Malad, this should.
Where is the scheduled property?
Yes, Malad. But the schedule of the property, Malad. Page, Malad.
Portion of land bearing
33 of the
yes,
application.
33 in page 11.
Yes, Malad.
Better than bounded by. Dependent
One of those where we take petrol every day, Malad. Every day.
Okay.
Malad, as a matter of fact, Malad, may I just give 1 minute of digression, Malad? Malad, this point, Malad, I had taken first against, Malad, before your lordship. When your lordship was sitting there, there was Joyanto Krishna Dotto, Malad, as far as I remember, where Mr. Abhijit Mitra was on the other side. There, after that, your lordship said that no, it's not a commercial suit. But subsequently, after your lordship has said no, these are commercial suits. So, Malad, I cannot lose twice. So this must be a commercial suit for a change, Malad.
Now, because of that's why I referred them T.A. Thompson to the full bench.
Definitely,
that's because.
But I think that is the right.
Because 4-5 matters I disposed. Subsequently, Mr. Thakkar has argued.
I know. I've seen that.
Then I have gone through the total. Then it was fine. Now it has to be settled. Then I referred. It is not good to.
Yes, well, because your lordship they would have 2 decisions. Well, yes, that is correct. But as a matter of fact, with regard to what Deepnath or the Deepak Polymers, I had a bit different take that even the single judge was not of the view that it is not a commercial suit. It was only a very small domain which he had carved out.
No, that's why.
It was making a lot of problems.
No, that's why the court has not gone into that the explanation clause.
Yes, not at all. Absolutely. That's why the court did not.
That's why there was a difficulty.
But from the very beginning, it was being read in such a fashion, Malad. Everyone was giving effect to that.
So because the court has only gone to the 106 termination.
That is what the court held. It did not give its mind to that, Malad. I know.
The proviso clause of the.
I saw that.
And this court also, while passing so many orders, not taken care of that also. Once it has been brought to the notice, the court. Yes.
So, Malad, here, Malad, this is the first thing. Second, Malad, my point is, Malad, that, Malad, kindly. Malad, that this property is a Thika tenancy property. Now, Malad, why do I say this? Malad will kindly straight away. First, Malad, their pleadings. Malad will kindly see at page 6. Page 5. Sorry, page 27 of my petition, Malad. Para 6. This is the plaint. Sometimes in 1981, after the promulgation of Calcutta Thika Tenancy Act, the defendant number 1 wrongfully illegally claimed to be a Thika tenant in respect of a suit premises. Huh? So, Malad, they also in their plaint.
Yes, Malad, I'm extremely sorry, Malad. Malad, your lordship has fixed a date on my matter, item number 1. The date is 22nd. Instead of 22nd, Malad, can it be possible on 29th? Because for that reason, Mr. Banerjee has asked adjournment today. The same bench is, Malad, sitting on 22nd at 2 p.m.
29 good, then first matter, no?
Grateful, Malad. Sorry for the trouble, Malad.
Yes.
Sorry. Now, Malad. So the plaint itself incorporates into it, my lord, the assertion that I have taken the point of Thika tenancy. My lord, why I'm referring to this, my lord, I'm going to be referring to the Church of Christ judgment, my lord, where I can bring in documents related to the pleadings if it has not been disclosed. Now, my lord, here I have disclosed, my lord, kindly sees. My lords will kindly take from page 87 onwards, my lord. My lord, this is a letter issued to the defendant number 1. My lord, I have shown your lordship the paragraph which says that I am holding through the defendant number 1. Now, premises number 87A Park Street, in connection with the return referred to the above, we are requested to appear before the undersigned and with all relevant documents in the office chamber of such and such at such and such. So, my lord, the return was filed and there was a hearing going on.
Yes.
Then, my lord, kindly takes. Huh? Well, it takes the next page now. This is to inform you. Well, kindly sees. This is being issued by the Thika tenancy officer in charge to me. Different number 2 asking for ground rent. But what else will I show? The state is asking rent from me. The Thika tenant authority is asking rent from me. So, my lord, it is, my lord, your lordships have a distinction that sometimes we see the corporation records, whether it is H or T or not. Well, this is not required because this is the Thika controller who is asking for ground rent from us. And, my lord, we have also been paying. And the return is Bharat Petroleum Corporation.
Yes. Yes, next.
Then, my lord, we have been making payments. And, my lord, will kindly see 94. Again, a demand notice, my lord. This was of 2011, my lord. Asking for rent from 1982.
Yes.
Of 12,49,000.
Yes.
So, my lord, this can be nothing but a Thika tenancy. Now, my lord, the reply. What the reply to? Now, my lord, under the Thika Tenancy Act, my lord, your lordship knows there is a bar on civil suit. If they are disputing that, they will have to go there and get it settled, the disputed question. But as on today, when ground rent is being paid and demanded, my lord, the landlord tenant, my lord, excuse me, well, the relationship is established on the face of it. Reply to the না ঠিক আছে কি বলেছে এটা 21 টা দাও AR ওরা ওই এও মানে kindly sees the affidavit in opposition now.
Yes.
আমাদের কোন প্যারাগ্রাফে ডিসকাস করেছি মানে we have disclosed this in paragraph
5 and 8.
Paragraph 6C, my lord. 6, my lord. Your lordship will kindly see in paragraph 9 of their opposition, my lord. Very interesting, my lord, because I point out, my lord. They do not deny these documents, saying that it is beyond the provisions of Order 7, Rule 11, 1. And next is defendant number 2 is trying to run a case, excuse me, my lord, which has not been made out by the defendant number 1. But I have made out the case of Thika tenancy. I am saying, and they have also said I am through the defendant number 1. The notices were issued to first the defendant number 1 and then on me. So therefore, my lord sees that they do not in any way, my lord, oppose the veracity or the validity of the documents, which clearly shows that rent was being paid. Now, my lord, with regard to the earlier one, my lord, that I cannot submit documents and it cannot be looked into at this stage, my lord. No, paragraph 29. The Church of Christ. And I'm referring for this.
Which citation?
This is, my lord, I'm sorry, my lord. This is 2012, 8 Supreme Court cases 706.
Yes, that's yeah, you relied upon.
And I have relied on that, my lord.
Paragraph
And
18.
yes, my lord, and I don't think, my lord, they have distinguished it in any form. No judgments. Judgments in the and my lord, no judgments have been shown. So this is what was submitted. So first point is commercial, and second is, my lord, this is TICA. It is covered by TICA. The cause of action is also of a TICA in TICA nature. And these are my submissions.
Thank you.
2 cents, because arguments have been made in facts in reply. So 2 points that I need to indicate to your lordship. First is, the lordship has seen the pleas. In one hand, they are saying it's commercial. In the other hand, they are saying TICA. If it's TICA, then there cannot be an agreement between me and him. So commercial court act cannot be applied in this case. If their stand of TICA is at all maintainable. The otherwise, we are shown on the earlier occasion.
If this court will find that if it is not a taken agreement ended between the parties,
Yes,
then the rent is been
there is no such agreement between the party. They have not shown, I have not shown.
It is admitted that there is a petrol pump.
Yes, petrol pump is admitted. That is there.
If it is exclusively used for the purpose of the business,
Yes,
what would be
exclusively used
effect
for
of,
commercial purpose.
what would be effect of the commercial court?
Lordship remembers that matter T. Thompson we had done. The same question came. Exclusive use of commercial. That's first. Second condition is then the primary condition is that use has to be legally sanctioned by way of some agreement.
Yes, it's there.
Along with that, in this case, between me and the defendant number 2, there is no such agreement. He is claiming right through defendant number 1 who has not come to court, filed an application, did not file written statement. So his defense is not on board, or his contention is not on board. And point number 2 is if it is TICA, then naturally he is not paying anything to me. He is paying according to his case, paying to the government. So even if there is any understanding that is between him and the government, not between me and him, I have challenged those proceedings that he has not shown. The pleadings are there. I have challenged those proceedings in writ petition before this court, which is pending. The TICA proceedings. I have said
what will happen to that?
Pending for adjudication.
So what will the effect of the suit?
So far as the questions of TICA is concerned, Lordship has also passed decree on that point, saying TICA court, this court can't entertain.
Correct.
Court will not enter into the question of TICA, this court, unless there is a declaration by the proper forum. In this case, they have not shown any document. Neither that document is annexed to the plaint. That declaration of TICA has been done by any court, any proper forum. Somebody has asked them to pay, they paid. That's all. Lordship is also aware of that judgment. Lordship considered that. I have not cited it, but Lordship considered the judgment.
Which judgment?
Ramnath Jhunjhunwala decree that Lordship had passed. Lordship had considered the judgment where it has been held judiciously that paying rent does not make any property a TICA property. Paying rent to TICA controller. These are settled. All that documents that they had shown are those documents. The TICA rent that he is paying, government asked them for TICA payment, TICA rent, that's that. Payment by making payment under TICA controller, the property won't become a TICA property. The declaration is not there. Neither they had shown, neither I am showing. So those documents are beyond pleadings. Even then, if Lordship considers those
beyond pleadings,
the declaration or the rent, I have not part of my plaint. So the citation that my lad friend had indicated on the last occasion also says court can look into the document if it is referred in the plaint.
No, so with regard to the 94, whose document is there?
He has disclosed my document. He has disclosed. I have not disclosed.
On the basis of his paragraph 18.
So he is showing from his documents, he is showing that I am paying rent, making payment to rent authority. The property won't become TICA. He has not shown any
distinction because he is making a reply on a reply.
No, reply not because showing facts.
I am trying to correct
but
your
this should not be permissible. Very well.
Then I will oppose his reply.
reply facts
Okay. If you have not heard, then don't say all these things.
You are replying anyway.
My submission is not I am paying rent. It's the other way around. TICA Tenancy Act has 2 ways. One is the government will demand, or the other will be, I want it to be a thicker tenancy. Here the government is demanding.
Yes. Now, my lord,
That's why your case is that
Therefore,
that the government is. But
therefore, my lord, the distinction, what your lordship had passed there,
to whom you are paying the rent?
to the government.
Still.
Yes. And my lord, that is the distinction from your lordship's judgment. Even that Jayanto Datta judgment was also there, my lord. Your lordship was of the view that if you filed a return, that will not make it a thika.
Same.
The incidence of landlord tenancy must be there. And this is what is the incidence. That ground rent is payable.
Okay.
And one last thing, my lord, as a defendant, I can run two cases. A plaintiff call, a defendant call.
That is absolutely self-destructive. One hand commercial, another hand thika. It can't be both. He has to choose a defend. It can't be. A thika property cannot be a commercial property.
Two issues.
Yes, so will the tribal can't be decided in order 711 if he is raising issues. His case is of order 711. His not case is not of the trial.
No, I'm saying barred by law.
So not if it is tribal issue. If my land friend is showing that whether this court can decide the question of thika at all.
It's section 4.
No, my lord, this is, my lord, rule 14 of thika tenancy, rules, my lord, 2004. If a thika tenant has defaulted in paying rent, controller may, after giving a thika tenant an opportunity of being heard, order him to pay the rent with interest with or without penalty. So this is what has happened. They are asking for the rent.
Yes.
And that is what 94 says, that I will take eviction steps.
Okay.
I'll
That's all. File notes.
I'll file a short note. Very good.
I'll file a short note.
Hearing concluded. Parties are directed to file written notes of argument. This is the matter. On 22nd has to be mentioned only for file written.
One liberty, that judgment I'll refer, my lord. Grateful.
Next.
Item number 3. Well, I am opposing this application. Well, this is an application under order 7 rule 11 for rejection of my claim. Lord, your lordship was pleased to hear my adversary on last occasion.
Defendant number 1, lordship, I'm praying for not today, lordship. Not today, lordship.
Yes.
I'm for the defendant number 1 and praying for not today.
Why?
Because the advocate on defendant number 1 is Rackburg. He is out of station, lordship.
My lord,
It is your application.
my lord,
He just instructs me, but I'm.
Yes.
my lord, may I submit this? My lord, since your lordship was heard at length, the defendant petitioner here. My lord, if your lordship give me chance to submit my case, then I can proceed with. Since they are not there,
No,
it is your law. I am leaving it to your lordship.
It is their application. They have to.
Yes,
they
my
have
lord,
to-
your lordship was kind enough to heard them. That is why it is part heard. And only 2 points have been raised. My lord, now one is this should be filed in commercial division, number 1. Number 2, the claim is barred by limitation. This is a 2, 1 letter is there, wherein they have admitted my claim after the expiry of limitation period. So I filed the suit. At page 37.
When
your
you will
lordship
available about the defendant number 1, lordship.
When?
কবে appear করতে পারবো?
After 1 week, lordship.
Okay, come on, 15th.
15th.
Lordship.
1 week, 15.
Sorry.
I am going by your words.
No.
As per prayer made by the counsel for the defendant number 1, case is adjourned. Let the matter appear on 22nd. Yes.
22nd, my lord. 22nd আছে কিছু? দেখ. 1 minute. My lord, kindly, my lord.
Yes, check it.
1 minute. No.
Yes, next.
Deeply obliged. Well, I was also missed in some time, so I didn't raise any objection.
আমরা এদিকে থাকি, হ্যাঁ।
Mr.
I
Kunal
had
is
finished
leading
my-
me. Yes.
I had finished my arguments, my lord.
So that's my comments, but may I, he's on his way. May I start him?
Yes.
Yeah.
So that one.
But yes, Malat. Revocation, Malat.
Yes.
That matter where Lordship will remember that there was Anushwa Pujara had applied for letters of administration. She was claiming to be the only surviving legal heir. Yes, in the second class. She had applied for letters of administration at an age of 98 years, in 89 years old. Within in the first two orders, in one order, it was disposed of, allowing her to carry out, granting her the letters of administration. And immediately after the letters of administration was granted,
Only the
she
reply is
passed away.
required.
Yes, she passed away. Just to recapitulate on the facts that, may I?
Yes, yes, yes.
Yes.
But they have moved an originating summons behind her back.
Yes.
Now, the points that they have taken, the points that they had, the plaintiff has taken is that the rule of survivorship does not apply in this case. Please correct me if I'm wrong. The rule of survivorship does not apply in this particular case. Second point they have taken is that the second point, we had argued that there was a will which has been suppressed by the plaintiff. It has suppressed because it was by the same advocate. They ought to have mentioned in the petition there is a will, and that has been subsequently found out that it has been revoked, and that the beneficiaries are so and so. However, these are the heirs. These particular pleadings are missing in the application for letters of administration. In answer to that, the plaintiff has said that this pleading ought not to have been there because these pleadings ought not to have been there because this is not required in a letters of administration. The third point they have taken, Mr. Dutt is leading me, will allow.
Tell me if I'm wrong. I said you're wrong.
Milord, my learned friend has argued basically 2 points, not 3, 2. His first and principal contention, if I remember correctly, is that he says that after the promulgation of the 2005 amendment to the Hindu Succession Act, the survivorship mode of inheritance has come to an end, and thereafter it follows the testamentary, and therefore class 1, class 2 comes. The second argument is, if you look at class 1 and class 2, I am sister in class 1, class 2, but I am prior, so therefore I need not cite anybody below me. That is his second contention. His third contention is that since I need not serve anybody and nobody has any interest in the property, therefore the question of citing anybody does not arise. And the fourthly he says, which is his second point basically, is that so far as the will is concerned, since the will was revoked by way of a registered document, he did not have brought it to the notice of the court because the fact remains the will was not there. These are the 4 points. So, Milord, in answer to the first 3 points, what falls for consideration is Section 6. And his principal argument is Section 6. Now, Milord, he cited 2 authorities also on Section 6. One is a 2020 and another is a 2023 or 24, I don't remember. Now, Milord, your Lordship will kindly take at which point? Kindly, my lord, take the genealogical table. Report. That's it.
Yes.
Kindly, my lord, take the genealogical table. And my lord, if your lordship has had a Hindu Succession Act was amended. Briefly, my lord, if I may just reiterate the facts of the case. My lord, your lordship is at page 14.
Yes.
My lord, we are dealing with the letters of administration of the gentleman named Damodar Das Wadhwa, who is in the middle of the table.
Yes.
Now, two facts are admitted. One is this Damodar Das Wadhwa belonged to a Mitakshara family. So his succession will be governed by the Mitakshara law, number one. Number two is that so far as Millard, the probate application is concerned, or the application for letters of administration, it gives a list of assets, but it does not say anywhere that these assets belong to Damodar exclusively, or it was his self-acquired assets, because that will make a world of difference. Now, if it is a Mitakshara law and the amendment applies, then it came somewhere in 2005. 9th September 2005 is the amendment. And the death of Damodar Das Wadhwa is 29 July 2022.
Died on
29 July 2022.
Yes. Yes.
Now, Miller, if your lordship comes to the genealogical table,
Will be lordship leave minute. But if any further facts one is arguing minute, I'll come back and assist your lordship.
No, I'm not arguing anything on facts. Anyway, they can. Now, Miller, if your lordship sees 2005, if your lordship keeps in mind, then Gurudas Wadhwa died in 2018. The first one.
1812.
Miller?
1812,
Yes,
18.
2018. Dungeshwari died on 26th of August 2015.
No,
No,
Tungeshwari died
2004.
2004.
2004.
Prior to the act.
Yes.
Amendment, sorry.
The Damodar Das Wadhwa died in 2022.
Correct.
Anushwa died in 2024.
Correct.
And Kusum died in 2021. If 2005 is the amendment, now kindly take section 6. What is the law that was and what change that has taken place? Millard, kindly keep these two genealogical tables side by side. I'll show Millard. I'll try. On and from, Millard, your lordship has the section 6. On and from the commencement of the Hindu Succession Amendment Act 2005, in a joint Hindu family governed by Mitakshara law. Joint Hindu family governed by Mitakshara law is admitted in the daughter of a Koparsana shall by birth become a Koparsaner in her own right in the same manner as the son. If Damodar was a member of a Koparsanary, the Koparsanary property of the joint family which we are talking of starts from Jerambai Wadhwa. Jerambai Wadhwa. His and the two lines thereafter. So in 2005, when the law came into force, by birth, all the legal heirs, those who were surviving, on the day when Jerambai died, became co-parceners in the property.
59.
So therefore, by birth means the daughters, previously Milord, the sons were there, the daughters also became co-parceners in the Mitakshara family of Jerambai Wadhwa. Then, save the same rights in the co-parcenary property as she would have had if she had been a son. So whatever rights Damodar had in the Mitakshara family, the two sisters will also have. We are talking of 3 sons and 2 daughters of Jerambai.
No, Jerambai Wadhwa died on 18/8/1959.
18/8/1959. The law has been declared to be retroactive. That means that if the persons, the daughter whom we are talking of in 6A, if she was born as on the day of the demise of Jerambai Wadhwa, she gets a right in the property by virtue of her birth. So by birth become a co-parcener in her own right.
So they are the 5.
They are 5. So the co-parcenary property becomes 5. The only thing is probably Milord, yes, 5. Then subject to have the same right in the co-parcenary property as she would have had she been the son, but subject to the same liabilities in respect of the property as that of a son. That is not relevant. And any reference to a Hindu Mitakshara co-parcener shall be deemed to include a reference to a daughter of the co-parcener also. So, Milord, on coming of the Act in 2005, all these persons become co-parceners, particularly the daughters. Provided that nothing contained in this subsection shall affect or invalidate any disposition or alienation, including any partition or testamentary disposition of property, which had taken place before the 20th of December 2004. Does not apply here. Nobody's case. Any property to which a female Hindu becomes entitled by virtue of subsection 1, which is by birth of 2005, shall be held by her with the incidence of co-parcenary ownership and shall be regarded, notwithstanding anything contained in this act or any other law for the time being in force, as property capable of being disposed of by her by testamentary disposition. So, in 2005, when the daughters came in, there were 5 co-parceners in that property of Mitakshara of Jerambai Wadhwa. So, it cannot be argued that Damodar Das, being the sole surviving person, and the day that Damodar Das, on the death of Damodar Das, Anushwa was the sole surviving sister, and she will get everything. Because that's the case. Anushwa had applied on the ground that I am the sole surviving person, and therefore the entire estate should come to me. If 2005 law applies, which my learned friend argues, which probably is correct, then in 2005, Kushum had also become a co-parcener, and the other 3 co-parceners who were male were already there. So there were 5 co-parceners in that property. So how do you now differentiate? Now, this is what Milord, the new amendment, has done. Milord, where a Hindu dies after the commencement of the Hindu Succession Act, Amendment Act, his interest in the property, now Milord, his interest in the property can be of 2 nature. One is his
or inheritance
or common property.
Correct.
Now, in the property of a joint Hindu family governed by Mitakshara law shall devolve by testamentary or intestate succession, as the case may be under this act, and not by survivorship, and the co-parcenary property shall be deemed, this is very important, Milord, deemed to have been divided as if a partition had taken place. So, Milord, prior to Damodar Das Wadhwa's death, if the co-parcenary property was partitioned, then so far as the common properties are concerned, there would be, he will have only 1/5.
Correct.
Correct. So if he has 1/5, then so far as the common are concerned, all the other co-partners will have a right. My lord, if that is correct, and if I have a right, then my lord, it is a self-defeating argument that only I get entire thing and the rest of the co-partners do not get anything.
So you mean to say if we go by the Amendment Act also?
That we have to go by to the, because
Correct.
yes.
That's why you go to the Amendment Act. So Jambabai died in 59. Already co-partner property.
In 2005, all of them became
5 persons are the co-partner share of over the property left behind by Jarambabai Vadhava. And after the death of the Damodar Das, automatically it will go to the other.
So the test is, if Damodar Das has died on 27th of July 2022 and the property was partitioned prior to that, there would be two levels of partition. One is his right in his own property, which would have, suppose Mr. Damodar had 5 sons or 3 sons. In his own property, each will have 1/5. His 5 sons will have 1/5. But the property which he is inheriting from Jarambai Vadhava, which he has because this says it's a Mitakshara law, that by virtue of 2005 amendment has also gone to the daughters because the sons were already there. The male were already there. So, Millard, if you apply this, Millard, if the by birth, which is Millard now that has come in, then Millard, obviously I have a caveatable interest. I was arguing on the question that under 275, I am the relative, I was entitled to this. Because of the simple question during inherit, Millard, when letters of administration was obtained, Millard, if your lordship sees the order, Millard, this question was not even taken into consideration. My learned friend brings it and says that I had excluded everybody because I am proceeding on the basis of 6.3. If you proceed on the basis of 6.3, then 6A, I already have a right. Those persons whom you have not cited.
Not by survivorship. Okay. Yes.
Now, Millard, and not by survivorship, and the co-partnership property, that is Millard property held by Damodar Das Vadhava and the other co-partners. This would mean that.
Correct.
Shall be deemed to have been divided as if partition had taken place. The daughter is allotted the same share as is allotted to her son. Millard, this partition was introduced only for the purpose of ascertaining the share in the Mitakshara. And the share is equal. So if Damodar Das has 1/5, Pujara will have 1/5, Kusum will have 1/5, Dungeshwari have 1/5, Ganu will have 1/5. Then the share of the predeceased son or a predeceased daughter, as would have had been alive at the time of partition, shall be allotted to the surviving child of such predeceased son or of such predeceased daughter. Now, Millard, Dungeshwari was a predeceased son. He died in 2004, but he was a male. So he was a co-partner. So in the case of partition, his surviving children automatically will get an equal share.
Dilip and Bhushan.
Dilip
and Bhushan.
Yes. The third one. And the share of the predeceased child of a predeceased son of a that is not very relevant. Now, Millard, the explanation is very relevant. For the purpose of this subsection, the interest of a Hindu Mitakshara co-partner shall be deemed to be a share in the property that would have been allotted to him if a partition of the property had taken place immediately before his death, irrespective of whether he was entitled to claim partition or not. After commencement, the only obstruction while section 6 is after the commencement of the Hindu Succession Amendment Act, no court shall recognize any right to proceed against a son, grandson, or great-grandson for the recovery of any debt due from his father, grandfather, great-grandfather, solely on the ground of pious obligation. This is not relevant. Provided that nothing in case of debt contract, that is also not very relevant. The right of a creditor to proceed against the son, any alienation made for the, then Millard, this is not very relevant, and my learned friend has not relied upon. What my learned friend did, Millard, I was listening to his arguments. He stopped at subsection 3 and 3 only. The partition concept, which he had very lightly relied and said that there is a concept of partition, is the place where, my lord, where the rights of other persons come in. So, my lord, if Jerambai Wadwa's property in 2005 had 5 co-partners,
yes,
then, my lord, by operation of law we come in.
inevitable.
So, my lord, not only do I have a slightest interest, I have a caveatable interest. If I have a caveatable interest so far as the common properties of Jerambai Wadwa are concerned, my lord, my learned friend kept on saying that this is something which is a question of title, the late court cannot decide. My lord, the primary question is, if your lordship looks as 276, my learned friend will have to have disclosed as to which property he is seeking letters of administration to and why is he entitled to. He said why is he entitled to. He is given the assets without indicating or without reading a line there that these are the self-acquired properties of Damodar Das Wadwa.
Okay.
So, my lord, section 6, right? So, section 6, my lord, actually, my lord, opens up the entire thing. Now, my lord, on section 6, the first judgment, initially, my lord, when 2005 came in, there was a lot of dilemma going on as to whether it was retrospective, whether it was prospective, and ultimately, my lord, the judgment which my learned friend cited is the judgment, my lord, which settled the issue. And they said it is neither retrospective nor prospective, it's retroactive.
Which judgment?
My lord, it's 2020, volume 9, SCC, page 1. Yes, my lord, the big one. My lord, my learned friend has relied upon paragraphs 50, 60, and 61. But I will, my lord, first take your lordship, my lord, to the issue that was there and the ultimate conclusion. Thereafter, I'll come back to. My lord, kindly take from paragraph 1 the question. The question concerning the interpretation of section 6 of the Hindu. I'm sorry, my lord. My lord, it will be probably page 21.
Got it.
Yeah. My lord, the question concerning the interpretation of section 6 of the Hindu Succession Act 56, as amended by the Hindu Succession Amendment of 2005, has been referred to a larger bench in view of the conflicting verdicts rendered in the 2 division bench judgments of this court in Prakash versus Fulvati and Danamma versus Amar. It was connected matters. In other connected matters, the question involved is similar. As such, they have also been referred to for hearing along. In Lokmani versus Mahadevan, the High Court held that the Section 6 as amended by 2005 Act is deemed to be there since July 1956 when the 56 Act came into force. The amended provision was given retrospective effect when the daughters were denied rights in the co-partner property pending proceedings are to be decided in the light of the amended provisions. Inequality has been removed. The High Court held that the oral partition and unregistered partition deeds are excluded from the definition of partition used in explanation to amended section 6.5. In Balchand versus Poonam, the question raised is about the retrospectivity of section 6 as substituted by the 2005 Act, and it is the case the father who was a co-partner in a joint Hindu family was not alive when 2005 Act came into force, where the daughter could be a co-partner of a Hindu family. So, date of death. Then, my lord, the other cases, my lord, what was cited, and my lord, now, my lord, this discusses from the very beginning of the Hindu Succession Act, the Mitakshara law, and goes on with the entire discussion. I am not troubling your lordship with the discussion because it's a very lengthy one. Kindly come straight to paragraph 137. For our purpose, this is sufficient, my lord, I believe.
Yes.
It starts, my lord, resultantly we answered the references under.
Yes.
The provisions contained in substituted section 6 of the Hindu Succession Act 56 conferred status of a co-partner or a daughter on the daughter born before or after the amendment, in the same manner as son, with same rights and liabilities.
Clear.
The right can be claimed by a daughter born earlier with effect from 9/9/2005. With savings as provided in 6(1) as to the disposition or alienation or testamentary use which has taken place before. So, daughter, whether it's born prior or after, the right comes from 2005. Unless there is a registered partition, the daughter gets a right straight away, equal to that of the son. Since the right is since the right in co-partnership is by birth, it is not necessary that the father co-partner should be living as on 9th of September 2005. So, my lord, even if the father had died, if the daughter was alive and was born when the father had died, then, my lord, that's good enough. She becomes a co-partner. A statutory fiction of partition created by the proviso to section 6 of the Hindu Succession Act 56 as originally enacted did not bring about actual partition or disruption of co-partnership. The fiction was only for the purpose of ascertaining share of deceased co-partner when he was survived by the female heir of class 1 as specified in the schedule to the 1956 Act or male relative of such female. The provisions of the substituted section 6 are required to be given full effect. Notwithstanding that a preliminary decree has been passed, the daughters are to be given share in the co-partnership equal to that of a son in pending proceedings for the final decree or in the appeal. So, my lord, this concept of notional partition actually does not break the property, it only declares who have a share. And for our purpose, to show that I have an interest and was entitled to notice, section 6(5)(a) is 1(a) is good enough.
Correct.
Then, my lord, in view of the rigor of the provisions of explanation to section 6(5) of the 56 Act, a plea of oral partition cannot be accepted as statutory recognized mode of partition effected by a deed of partition unduly registered under the provision registered or effected by a decree or order. However, in exceptional cases, plea only is supported, but this is not our case. There is no case of oral partition. We understand that on this question, suits appeals pending before different courts and subordinate courts, the matter has already been decided in level. So, my lord, this is what the Supreme Court has given an interpretation as to section 6, which in plain and simple language is that the daughter has to be alive on the death of the co-partner.
So he is having a co-partner property.
Absolutely same as that of the son. Now, my learned friend had relied upon paragraphs 50, 60 and 61. Millet 50 is Millet the section which was there under the 56 Act. 50 your lordship will find at page 48.
Yes. That is the old act.
That's the old act and the new act comparison. And thereafter my learned friend has gone to paragraphs 60 and 61. Kindly Millet see 60 and 61.
Yes, dealt with the 53 also.
53, I'm sorry. Yes, let's take 53. Section 6 deals with devolution of interest in co-partnership property of a joint Hindu family governed by Mitakshara law. The originally enacted provision of section 6 excluded the rule of succession concerning Mitakshara co-partnership property. It provided that the interest of a co-partner male Hindu who died after the commencement of the 1956 Act shall be governed by survivorship upon the surviving members of the co-partnership. The exception was provided that if the deceased had left surviving a female relative specified in class 1 of the schedule or a male relative specified in that class who claims through such female relative the interest upon the co-partner shall devolve by testamentary or intestate succession as the case may be. In order to ascertain the share of the deceased co-partner, the partition has to be deemed before his death. And explanation 2, disentitle the separate person to make any claim in respect of. This is, my lord, the old law. So therefore, my lord, concerning then, my lord, if I may go ahead, since I'll be reading 60. Though the widow of the daughter could not claim a share against being a class 1 heir in the property laid by the deceased co-partner, and the widow was entitled having a right to claim a share in the event of partition, daughter was not treated as a co-partner. The goal of gender justice as constitutionally envisaged is achieved though belatedly, and the discrimination made is taken care of by substituting the provisions of section 6 of the 2005 amendment. Concerning gender discrimination, a daughter who always remains a loving daughter, we quote, this is Justice Kapoor's favorite line, I don't know, because I had the occasion to cite this. A son is a son until he gets a wife, a daughter is a daughter throughout her life. So, paragraph 56. A daughter is treated as a co-partner in the same manner as a son by birth with the same right in co-partnership property and liabilities. However, the proviso to subsection 1 contains a non-obstante clause providing that nothing contained in subsection shall affect or invalidate any disposition or alienation, including any partition or testamentary disposition of the property, which shall take place in 20th of December 2004. This partition is not there anywhere, so Millard, I am not.
That is not there.
Yes. Now, Millard, kindly come to section 60.
Page para 60.
Yes, para 60. The amended provision of section 6(1) provides that on and from the commencement of the Amendment Act, the daughter is conferred the right. Section 6(1)(a) makes a daughter by birth a co-partner in her own right and in the same manner as a son. Section 6(1)(a) contains the concept of unobstructed heritage of Mitakshara co-partnership, which is by virtue of birth. Section 6(1)(b) confers the same rights in the co-partnership as she would have had if she had been a son. The conferral of right is by birth, and the rights are given in the same manner with incidents of co-partnership as that of a son, as she is treated as a co-partner in the same manner with the same rights as if she had been a son at the time of birth. So, Millard, if Damodar had two sisters, they had already become co-partners in 2005, having the same rights of Damodar in respect of the property in question. So, Millard, suffice it to say this much, that if you are asking for letters of administration of a Mitakshara family, you can't exclude the persons after 2005. The daughters or their legal heirs, whoever the child, ought to be cited. Though the rights can be claimed with effect from 9/9/2005, the provisions are of retroactive application.
Yes.
They confer benefits based on antecedent event, and the Mitakshara co-partnership shall be deemed to include a reference to a daughter as a co-partner. So whenever Damodar and the two brothers became co-partners, I also became a co-partner, subject to all rights and liabilities. At the same time, the legislator provides a disposition and alienation. I am not Millard. The prospective statute operates from the date of its enactment, conferring new rights. The retrospective statute operates backwards and takes away or impairs vested rights acquired under the existing laws. A retroactive statute is one that does not operate retrospectively. It operates in future. However, its operation is based upon the character or status that arose earlier. Characteristic or event which happened in the past or requisites which had been drawn from antecedent events. Under the amended section 6, since the right is given by birth, that is an antecedent event, and the provisions operate concerning claiming rights on and from the date of amendment. Then, Millard, retrospective prospective is discussed. My learned friend has not relied on it. So, Millard, it's settled law today that if it is retroactive and my right, I say that this judgment does not assist my learned friend in any manner. On the contrary, Millard, this throws light on the question as to what right the other members, Millard, if your lordship now, the genealogical table comes to page 19. Page 19.
Yes.
That Damodar Jas Wadhwa died, was a bachelor during his lifetime, and at the time of his death, a permanent inhabitant of such and such, governed by Mitakshara school of Hindu law. That is one. And Millard, if section 6 applies, and the son and daughter of a predeceased son gets the same right through her mother, if under Millard 6b2, then Millard, this genealogical table at page 11, Millard, is a complete suppression.
Page 11?
Page 11, the one which was applied to the letters of entry.
8 is the one that they have.
The 11th, oh, I'm sorry, this would be page 28. I'm sorry, Millard. I was looking, page 11 is the number with the page 28.
Acha, they have given.
Yes.
So they have Jamrama by Bulchan Wadhwa, Vallabhai.
It stops there. There is a whole existing people under that, if your lordship compares with page 14, this second line is not there.
Yes.
So, Millard, the court was given an impression that all have died, only this man is alive. Order to the
Yes.
Just. Now, Millard, if your lordship had looked at that genealogical table without anybody to assist, your lordship would have come to the same conclusion which the learned judge had come at page 32.
Page 32?
32. Millard, your lordship is looking at GA1.
GA1.
আমাদেরটা তো 10x করা আছে। Oh, GA1, yes, page 32. Millard, this is the order which we are seeking recalling.
Supplementary affidavit filed.
No, Millard, it's an order of 20th July 2023.
20 July.
Yes. Kindly see, Millard, the first line.
Oh, supplementary affidavit filed by Yansuya Godda.
Being the only heirs in the intestacy in class 1.
Being one under class 2.
In class 2 of schedule contained in section 8 of the 56. By the time the affidavit tried to demonstrate that the estate of companies several stocks such and such, and the finding is considering the details furnished, I am satisfied that this court is authorized to exercise concurrent jurisdiction, the provisions of 300 of the despite restrictions provided in the City Civil Courts Act. Then, the only legal heiresses as stated in the application, and as such there is none to oppose the application. Millard, I could have understood, Millard. The second line was there. Section 6 was taken into consideration by the learned judge, then automatically, my lord, it goes without saying, my lord, a notice would have given. It would have also fallen for consideration before the learned judge that these persons are also relatives under 276. So even if the section 6 did not apply, they would have got notice either way. And my lord, if I may ask myself this question, when you see this genealogical table, which starts and ends in one line at page 28, my lord,
Yes.
so my lord, what remains? What? There are nobody to be even summoned.
Yes.
Had you indicated, then my lord, the court would have given it a thought whether they have a caveatable right or not. You did not even indicate. According to you, I may not have a caveatable interest, so you don't serve me. But that doesn't mean that you go and indicate that my brother has 3 sons, my daughter, this is the Mitakshara, constitution of the Mitakshara family is this, and under section 6, none of them are entitled. This can be argued.
Yes.
But you can't change the facts.
Yes.
Now, my lord, the other judgment, which my learned friend relied upon, is 2023, volume 10, SCC, page 1. My lord, he has relied upon 40, 49 to 51. I'll take your lordship through those, my lord. But, my lord, this is one of those copy-paste judgments, my lord. It goes on and on and on. Kindly see the issue, my lord, that was here. It has nothing to do with our case. The reference to the 3-judge bench, I'm sorry, my lord, at page 18.
Yes, yes.
The reference to the 3-judge bench is a child born to parents whose marriage is null and void under section 11 of the Hindu Marriage Act 1955 is declared to be legitimate child by section 16(1) if a child of such marriage would have been legitimate if the marriage had been valid. Likewise, where a decree of nullity has been granted under section 12 in respect of a voidable marriage, a child begotten or conceived before the decree is made is deemed to be their legitimate child if such child would have been legitimate child of the parties to the marriage if the marriage had been dissolved instead of being annulled. Section 16(3) enunciates that a child of a marriage that is null and void or which is annulled by a decree of nullity should not have any rights in or to the property of any person other than the parents, but where the enactment of the legislation such a child would be incapable of possessing or acquiring any such right by reason of his not being a legitimate child of his parents. Several decisions have been there. So this was, my lord, the issue. Kindly come to the finding. My lord, the conclusion is at page 851, paragraph 81.
Yes.
My lord, your lordship will find that this only deals with the right of a child born of a legitimate. It has nothing to do with the law which is laid down over here, has nothing to do with interpretation of section 6, except 81.6. 81.6, my lord, has been considered vis-a-vis the rights of the child.
Yes.
Section 6 of the Hindu Succession Act 56 provides for devolution of interest in co-parcenary property. Prior to substitution of Section 6 with effect from 9/9/2005 by the Amending Act of 2005, Section 6 stipulates the devolution of interest in Mitakshara co-parcenary property of a male Hindu by survivorship or the surviving member of the family. The exception to devolution by survivorship was where the deceased had left surviving a female relative specified in class 1 of the schedule or a male relative in class 1 claiming through a female relative. In such event, the interest of the deceased in the Mitakshara co-partnership property would devolve by testamentary or intestate succession and not by survivors. In terms of subsection 3 of section 6 as amended by on a Hindu dying before the commencement of the Act of 2005, his interest in the property at a joint Hindu family governed by Mitakshara law would devolve by testamentary or intestate succession as the case may under the enactment and not by survivors. As a consequence of substitution of Rule 6, the rule of devolution by testamentary or intestate succession of interest of the deceased Hindu in the property of the joint Hindu family government law has been made to be the norm. No issues. No issues. That is what exactly section 6.3 said, and that is what I submitted. Now, the paragraph which my learned friend relies upon is very interesting. I am not very sure whether paragraph 49. Excellent.
49.
49. Excellent. No, there was, Millard, a example given as to how you will divide the two properties, one acquired and it's already 330. Millard 49, Millard, if I may read. Before the amendment of section 6 provided that on the death of a male Hindu, his interest in Mitakshara proportional property would devolve by survivorship upon the surviving members of the co-partnership and not in accordance with the mode of succession provided in the Act. Section 6.3 of the amended provision now stipulates that on a Hindu dying after the commencement of the amending Act, his interest in the property of the joint family governed by devolves by testamentary or intestate succession and not by survivorship. This is Millard, no problems with that. In Vinita,
Same, that one, which you referred.
I beg your pardon. Huh? Yes, all those judgments, Millard, have been cited. No, Millard, I was looking. Excellent. An example, excellent. Lordship, gives me a moment, Millard. I just forgot to. Paragraph
61. Property of the parents.
Paragraph 60. Yes.
61.
Example ta kothay ache re? Yes. Millard, kindly permit me to place paragraph 61 and 62 of this to show Millard what I was trying to argue. Property of parents. When a Hindu dies after the commencement of the amending Act of 2005, his interest in the property of a joint Hindu family governed by Mitakshara law has to devolve by testamentary interest succession and by survivorship as stipulated in subsection 3 of section 6. The interest of a Hindu co-partnership for the purpose of subsection 3 has to be ascertained on the basis that the notional partition had taken place immediately before his death. The share in the property that would have been allotted to the intestate on the basis of such a notional partition is governed by the general rules of succession specified in section 8, the HSA Act. The distribution of property among class 1 heirs is involved by the rules specified in section 10. In the distribution inter alia, the surviving sons, daughters, and mother of the intestate take one share each, and likewise the widows, if there are more than one, take share.
In the distribution of inter alia, the surviving sons, the intestate, take one share each, likewise the widow. Yes. Take one share. Then, in the distribution of the property of the deceased, died intestate.
Now, 62, if I may. In the distribution of property, the deceased who had died intestate, a child who is recognized as legitimate, such and such, This provision, my lord, section 16(3) comes in, is not very relevant. 62 subsection 3 of section 6 indicates a deeming provision that would constitute the interest of Hindu Mitakshara Koparsana. As already discussed, the deeming fiction requires an assumption of a hypothetical state of affairs in terms of which a notional partition is deemed to have taken place immediately before the death of. Now, let us assume, for example, that there are 4 co-parceners, C1, C2, C3 and C4. Here also we have 5 co-parceners. C2 is survived by the widow, a son and a daughter, but it so transfers that one of the child is from the marriage is null and void under section 11. Clause 2 would have 1/4 share in the co-parcenary, which consisted of him and his 3 brothers. This is where we are. C1, C3 and C4. Here we have 5. Now, in order to ascertain C2's share in the property and the devolution of his shares along C2's heirs, the explanation mandates an assumption that the partition took place immediately before C2's death. In such a partition, between him and his brothers, C2 gets 1/4. Here I am saying 1/5. 1/4 share in the larger co-parcenary comprising himself and his 3 brothers. This is where I am on. So, my lord, now within the own branch of C2, when I said, my lord, suppose Damodar had 5 sons, within the own branch of C2, his widow and his child born from a valid marriage would have had 1/3 share. In other words, the notional partition which is deemed to take place in terms of extension of the share is ascertained to be 1/3. Then, my lord, how this 1/3 is working out as per the is given there. So, my lord, it takes note of this notional partition concept, takes note of the larger co-parcenary. And that is where, my lord, I say that if you apply the provisions of section 6, my lord, I automatically. Now, these are the 2 judgments which my learned friend had cited on section. Please. Yes. So this, my lord, takes care of, my lord, my understanding of section 6, my lord, subject to, my lord, what your lordship holds. The other argument which my learned friend has cited is the original side rules to show that he is entitled to give citation only to the persons interested having a caveatable interest. Now, my lord, if rule 6 applies, so far as the larger co-parcenary is concerned, I obviously have a caveatable interest straight away. And the third, my lord, that's why, my lord, I am not going on this original side. And so far as, my lord, the third is concerned, he has said that my pleadings are vague because I have shown that this testator, I'm sorry, my lord, that there was a will by Damodar Das Wadhwa, which I had disclosed, which has been subsequently revoked. I have tried to draw a line through all these documents to show only one thing. I have not alleged fraud. I have only shown that the person who was applying for letters of administration had knowledge of the will. We had come to know subsequently when the application was filed somewhere. So, my lord, we did not know of the will. When we subsequently came to know, we brought it by way of an affidavit or whatever. Now, it is one thing to say that mentioning this is of no relevance. But, my lord, I have cited an authority for this proposition that whether it has relevance or not is for the court to decide, not for you to take a call. Like whether the other legal heirs in that co-parcenary are relevant or not is for the court to decide. You put in your facts. If it is shown that by not showing that, there is a possibility that you are trying to get an advantage or you may get an advantage, then, my lord, that is suppression. Plain and simple. Which, my lord, I had said so far as the general. Now, I do not know Had the judge, my lord, in my respectful submission which passed the order, Honorable Judge, my lord, was aware of the fact that look, there is a will, and the will as it shows is this testator's desire was that it will go to trusts. And the person today who is standing before me and asking for letters of administration has been expressly excluded. So, my lord, if I may ask myself this question, it takes nothing to give a notice, not for the purpose of opposing, at least to, my lord, see the proceedings that look, I am giving the letters of administration to somebody on the basis of these facts. If you have anything to say, please. He doesn't take a call. The person who makes it doesn't take a call. That is what I wanted to say. And it should be taken. আর কিছু বলার আছে? And my lord, so far as this family trust is concerned, my lord, your lordship had the occasion, my lord, to see a originating summons suit in respect of this same. And my lord, your lordship had seen, my lord, how a company has been made a trustee. And my lord, through him, the funds are being. The interim order, no, please. Your lordship has also passed an interim order, my lord. It's the same property.
Okay.
Those would be my submissions. আর কিছু বলার নেই তো?
Yes.
That I have not cited.
He has made certain submissions. I'll just take 2 minutes, my lord, if you like. Only on the judgment which I had cited, now he is relying upon, my lord. First, he has said that he has opened up his submission saying that he was relying on section 6. He never opened up on that, my lord. Section 6 was not the consideration section, what I had taken as a defense, my lord. But if your lordship kindly takes the judgment, my lord, but the judgment is in several parts. My lord, this is 2023 10 SCC page 1.
Yes.
One will kindly see the Hindu Succession Act was being dealt with in paragraph 39 onwards, my lord.
Yes.
And my lord, 40 onwards, your lordship will find section 6 as it stood prior to the amendment. The discussion is all on that. Excuse me, my lord. My lord, will continue with this, my lord, and my lord will kindly see when your lordship goes to paragraph 61.
Yes.
Property of the parents. But before that, my lord, it was all with regard to the prior amendment, what was happening. Now it says when a Hindu dies after the commencement of the amending act, his interest in property of a joint Hindu family governed by Mitakshara has to devolve by testamentary or intestate succession, not by survivorship. Now my learned friends is relied upon. But kindly sees he has taken 62. Just before that, my lord, your lordship will kindly see placetum F. Hence, where the deceased has died intestate, the devolution of this property must be among the children, legitimate as well as those conferred with legitimacy by the legislature under section 16(1) of the Hindu. Sorry, madam. It should be HSA, I believe. Whatever it is. Doing so would not offend or breach the restrictions present in subsection 3. Now 62. Subsection 3 of section 6 indicates by deeming provision what would constitute the interest of a Hindu Mitakshara. As already said, the deeming fiction requires an assumption of a hypothetical state of affairs in terms of which a notional partition is deemed to have taken place immediately before the death of the Hindu Mitakshara co-person. Who's that person here? Malad, I'm trying to identify this person. We are putting in the example. The Hindu co-personer would be the testator.
Why?
Yes, because Malad, we are talking about the death of the Hindu Mitakshara co-personer. The death is the testator's death.
Correct. When testator died?
In 2020? 2022?
2022?
Yes.
Correct. And when the father died?
Malad, that is what I'm on, Malad. when did the father die, my lord? That will not be the question of succession for my lord, ki naam hai? Damodar Das. But kindly appreciates, my lord. Today, my lord, when my learned friend is trying to draw it back to Jiram Das, my lord, my lord,
See, the property belongs to whom?
Damodar Das.
Damodar Das.
Yes.
And after the Damodar Das died, admittedly before the amendment?
No. After the amendment. 2022.
Jarambai.
Jarambai.
Jarambai, that's I'm telling.
Jarambai
Jarambai.
is not here, my lord. It is.
Jarambai
Yes,
died before the amendment. So Jarambai died leaving behind how many legal heirs?
5.
5.
Yes.
Correct.
3
So
sons, 2 daughters.
if the Jarambai died, so how many legal this property will be distributed?
Co-personary.
Co-personary at Hindu Mitakshara.
Which property? That is most important.
Co-personary.
Which property? My lord, today what my lord, this was my first submission. Today, my lord, my learned friend is trying to make this into a title dispute.
No.
Yes, my lord, because he's trying
Come
to.
to your application itself.
Yes, my lord.
Paragraph, page 19, paragraph 1.
Page 19.
Paragraph 1, page 19.
Yes, my lord.
Read paragraph 1.
Governed, yes, my lord.
Governed by?
Who's governed, my lord?
Governed by Mitakshar School of Hindu Law.
That's me.
So the other brothers and
What happened to the others? If the Jarambabai died,
my lord, we are not here with regard to my kind appreciates. Jarambai Das dies. As on that date, though, ওটাও কি পরে ছিল? কবে মানে ছিল?
So if X
before
died,
arrangement.
If X died,
X dies.
Leaving behind?
Let us say there are 5 properties.
5 properties. Five, not leaving aside the property, heirs.
But if I'm talking about the, I'm talking about the properties because it's
It
very
is not your case, this property, no. The property which you have filed the, got the administration is not with regard to the Jarambabai?
No, it is not. It is of Damodar Das.
How it has come?
Malad, that is what I'm on, Malad. Kindly appreciate. Then it's becoming a question of title. Why I'm saying this, Malad? Let us say, Malad, it's a very old anecdote we follow. Even the Taj Mahal can be a part of the affidavit assets. Malad, the point is, if it is being made a case of, Malad, title dispute or not, he's saying these properties belong to Jeremiah. That is, there is no foundation pleadings on that. He's saying it on his own. First of all, that. That's why I had also submitted, Malad.
So show me your
I had
property.
already shown, Malad.
Where is the details of the property? He got the property of his own. Show me that.
Malad, that is what I'm on.
Show
Malad.
me the Damodar Das Wadhwa got his property of his own. Matter and I will tell Mr. Das to go out from the court.
May I just ask myself this question, Malad? In a probate application, Malad, is this a question or not?
Of course. See, you have filed an application for grant of administration.
Yes, letters of administration. Yes, Malad.
Grant of letters of administration.
Yes.
And you are telling that you are only the heir. You are only the heir.
On the basis of will, Malad.
Correct. Will, whatever it may be.
No,
so from where you have to write something. This
Malad,
property belongs to
kindly
him. He had
No,
the
Malad,
interest and he has executed.
Malad, may I, kindly appreciates. Malad, let us take a step back, Malad. Malad, it will take me some time, Malad. Please
No
don't
problem, no problem.
Malad, let us say, as a matter of fact, a very, very light example I'm passing, Malad. My next door neighbor, Malad, Malad writes a will. And Malad gives details of properties. For some reason, I made the executor. Malad, I'm a third party individual. I'm talking about a principle. It's not this matter only. Malad, I will not have to disclose where this person got the property from. It is not required. What I will have to disclose, as these are the properties which I've been able to assimilate as if they are the properties. Excuse me, Malad. It's a very big thing. Malad. The same thing has happened there, Malad. The affidavit of assets would contain details of properties. Now, Malad, what is happening? The first statement in the revocation petition is that these are joint family properties. Malad. So, Malad, that is a question of title. It's a question of title. So, Malad, this first thing is beyond the scope of this application. Next, my lord, your lordship is putting me to task.
If that sentence is not given, it is the family property. If it is not given, so how the petitioner can claim the cavetable interest of the property?
Sorry, my lord.
Cavetal right, cavetable interest in the property. If it is
Petitioner.
not say, if it not say, if I
My
came,
lord, caveatable interest with humility, I say, is not related to the property. Is related to the person.
not leave aside that. Here is the property. Property is in dispute. What
again,
administration you got it? What administration you got it?
Sorry, my lord.
What letters of administration in which in respect of which property?
My lord, the ones which are mentioned in the will.
That is the landed property, immovable property.
Where is the will?
Sorry, and the affidavit. Sorry, my lord.
That is the immovable property.
My lord.
And this is not the will. This is only the letters of administration.
Yes, my lord.
So you have prayed that you are
disclosed.
only the legal, because that's why this court passed an order. Kindly come to the order which is under for revocation.
Revocation. 32, my lord. Yes, my lord.
32.
Yes, my lord.
Kindly come to the first line.
Supplementary affidavit filed by Onushua.
Being the only heiress of the intestacy, being one of the class 2 of the schedule contained in section 8 of whom?
Damodar Das.
Damodar Das. If how she can come, if he is unmarried, how she will be the only one here under class 2?
Well, that's what I showed you, lordship.
What?
Well, let us take two instances. Let us.
If you are telling that because Damodar,
we are not
Damodar died unmarried.
Unmarried, post amendment. My lord. Now the question is, let us take two situations, my lord. One, it is the property of Damodar Das.
Yes.
My lord, then what would have happened? That's a question which I'm going to answer now. My lord, I will only show that it is his property, and my lord, let us which I'm seeking for. This is one. So if the principle is for Damodar Das's property, I will only have to say what belongs to Damodar Das, not where he has got it from. My lord, if that was the case, my lord, then my lord, the person who's claiming today, my lord, would have had to make some kind of partition suit or something of that sort prior to Damodar Das' death when Jaram Das passed away.
Okay.
This is nowhere there. Now, my lord, your lordship will kindly give me one more day because my lord, kindly, my lord, I want to.
No,
my lord, this question has never cropped up.
What not? Since
No,
beginning,
no,
it's asking.
my lord, no.
Since first day, Mr.
May
Dutt has
one
opened his case on the same.
No, my lord, one thing, my lord, your lordship.
You cannot change the stand.
I'm not changing the stand, my lord.
Roy,
My
sorry.
lord, your lordship, my lord, one
That's
thing.
why this court can never disclose the mind.
My lord, then, my lord, your
By
lordship.
putting any questions to any
My lord,
advocate.
then may I'll just formulate my, my lord.
Formulate whatever question, you come with the written notes, you file the written notes.
But only one thing, my lord.
Every day the one matter cannot be taken.
One matter, my lord, kindly give you 1 minute. 1 minute.
You are telling that you are claiming and you are claiming that you are the one of the legal. So
Where did this
what
Jerem
about
bhai
the
come
other
from?
four? What about the other
I'm asking myself this question, my lord. Where did Jerem bhai come from? This is the first time I'm hearing this.
Leave aside Jaram bhai.
My lord, if I leave aside, I'm grateful.
If you go by
If
your
I go by
application,
Damodar
how
Das, my
you
lord,
can say you are only the one here?
my lord, I am
leaving aside the other
my
four.
lord, my lord,
So you
Damodar
could
Das.
okay, they are not entitled. You could have been made a party.
Yes.
You could have been made a party to them.
Kindly.
Okay, you are not entitled for that. They are not entitled. You could have been
lord,
disclosed the relationship.
Kindly give me 1 minute, my lord. Only 1 minute. Only 1 minute by the clock.
Yes.
Now, my lord, first, your lordship is giving me an instance where let us not think about Jaram Das.
Yes.
Only Damodar.
Yes.
Now, my lord, if I am Damodar Das is, my lord, no, I'm trying to take letters of administration for Damodar.
See, your simple case is you are claiming the property of Damodar Das as per the letters of administration. Being a class 2 here. This is your case?
My lord, kindly, it does not take me amiss, my lord. I am taking a letters of administration as a person who will give it to the persons concerned. In this case, my lord, it is me.
That's what I'm telling.
That is
letters of administration, there is no will.
No will.
Correct.
So letters of administration is for
only
administration.
as a administration as a here. You are claiming as a here, class 2 here.
Well, I'm claiming as a heir, as a class 2 heir. How I'm
if you are telling that you being a class 2 here, Okay, the other, I admit it, the other are not entitled for that, but you could have been disclose the details of the other heirs of the
For that, my lord, for that, my lord, I have shown, my lord, the original side rules.
Okay.
I've also shown, my lord, they are saying, my lord, they are asking that they are coming from Jaram Das. My lord, your lordship is.
I am not telling now. Okay, I am not taking care of the
Jaram
submission.
Das.
I am giving the 2 lines of the order of this court granted administration.
Yes, my lord.
Your specific case that you are claiming the property of Damodar Das as being the class 2 years.
I am.
Correct. Yeah. So if you are claiming that as administration, they are not entitled. But what is your duty? You have to make the disclose the name of the other heirs of the brother and sister. Leave of the
They are not
brother
the
and
heirs, my
sister.
lord, they are class 2. They are not the heirs.
You are kindly come to your application.
Yes, my lord.
What is this?
Yes, my lord. That's a genealogical table.
Then, if you're admitting that they are the brother and sister, why you not disclose
They are
the
not
name?
there, my lord. They are all predeceased.
Who?
That first line
could have been disclosed.
But first line, that's what it's disclosed.
Okay.
But it's disclosed.
Okay.
No, my lord, kindly. In my application, lordship sees, I've said that the
File written notes.
But I've said that they are predeceased.
File written notes.
No, my lord, kindly does not. Let us try and establish this one. My lord, I have in my application, I've said my line all are predeceased. Now, what else can I?
When predeceased?
Sorry, all given details.
When predeceased?
I'll give the
2022.
2022 is Damodar Das, my lord.
That's why you are claiming the Damodar Das, sir.
Yes, my lord. They are predeceased before that.
Who?
My lord, the other brother.
Who
Let's, my lord, kindly, my lord, I'm sorry, my lord, if I've my lord, made any submissions which made your lordship, my lord, lose. But I am only trying to establish, my lord, that I think I cannot communicate properly, my lord. I'm sorry.
See, you come with a specifically, the court will give a. I am giving the hearing to every day, but you are changing your stand up every time. Then
I think I'm not being able to my lord, make over my case properly, my lord, because I have disclosed my line.
This court is not giving. But
No, my lord,
if you are changing the stand up every time after hearing a reply, then it will be difficult for the court.
I've done that, my lord. I'm sorry, my lord. I've not done that. I don't do that. But I've said only one line. I've said that one line. There are heirs who have predeceased.
So where is your
pleading?
Pleadings.
Yes, well, it is there.
Where is the pleading?
In my petition.
Show me pleadings. So the pleadings?
Yes, I'll show, my lord. But I think I'm not being able to communicate, my lord, properly, my lord. Kindly take from paragraph 2 onwards.
Yes.
2, 3.
Yes.
They are my line.
Yes.
So they predeceased me.
Okay.
That's what I've said.
Okay. Okay. I'm
sorry, madam. I
will pass an order.
And that is okay, madam. Kindly does not take me.
Hearing concluded. CAV. You are not taking the chance of the filing written notes.
Yes,
I am not taking. Then I am asking from half an hour.
But I will. I'm sorry, my lord. I think, my lord.
Mr. Rib.
My lord, if your lordship does not want, my lord, I will not file. If your lord,
hearing concluded. Parties are directed to file their written notes of argument. Let the matter appear on 29th of August as to be mentioned for filing written notes of argument.
I'm sorry, my lord, before your lordship, my lord, rises, my lord.
Yes.
Item number 15, lordship would recollect, my lord. 15, 1-5, my lord. This is, my lord, I argued this matter, lordship was pleased to pass an interim order, my lord, suit for specific performance, my lord. The defendants have not yet filed their written statement, my lord. We have got the certificate from the department as well. Lordship, you can keep it any day, my lord, next week or week after, as your lordship's list is convenient, my lord.
Counsel for the plaintiff, item number 15, counsel for the plaintiff submit that prays for time to obtain report from the department to ascertain whether the writ of summons is served upon the defendant or not, and whether the defendant entered appearance in the matter or not.
They have entered, they have not yet in the suit, my lord. In the earlier suit, this is that matter, my lord, which was transferred from city court.
Now?
My lord, I want the suit to be heard, my lord, because, my lord,
so whether writ of summons served?
Yes, everything was done.
So what you want now?
But can it be listed as an undefended suit? That's
Where is the report? That's why I want to. Where is the report? Where the writ of someone served and none appears. Then I will record the undefended in the undefended list. Then the
Lakshman, then kindly pass a direction to that effect, Millet, and we'll Millet. I'm sorry, Millet.
क्या बोला?
For the plaintiff submit please for time to obtain report from the department to ascertain
Whether the defendant and whether the writ of someone was served upon the defendant or whether then whether the
whether the defendant
entered appearance in the matter or not. Let the report be filed by 22nd.
22nd. Deeply obliged.
Let the matter appear on 22nd.
I'm sorry, Millet.
Okay. Yes, next.
Lordship,
item number 22. Malad, this is a contempt matter. The interim order is expiring today. That's why I'm troubling your lordship. Otherwise, I wouldn't have.
22.
But I appear for the alleged contempt. The interim order can be extended. I can't oppose that. Only thing is that Mr. Ghosh is in reply. I believe he will not take much time. I was beseeching your lordship if it could be listed slightly at the top, on the next available day.
Yes, I'm not opposing to
Next
that.
Friday is a holiday.
Now, which is today, which item?
Item 20.
22, my lord.
Item number 22. Counsel for the plaintiff. Which matter?
It's
This is that Sanai matter, the
deeds
contempt.
have been-
Deeds.
Yes.
Mr. Mitra had appeared.
Yes, Mr.
Yes, my
Mitra.
lord. Yes, my lord.
Counsel for the petitioner. Praise for extension of interim order. Police counsel for the alleged contempt submit that the case is at the stage of final hearing and praise for fixing a specific date so that the matter can be disposed of. In view of the submission made by the counsel for the plaintiff parties, the interim order is extended till 29th of August 2025 or until further order. Let the matter appear on 29th of August at the top.
My lord, so deeply obliged.
At the heading contempt matters.
My lord.
Grateful.
May I have your lordship's kind leave, Malad, to mention item 44.
44.
That doors matter, Malad, against the State Bank of India. Malad, the interim order is due to expire today.
44.
Yes, 44 in today's list, Malad. Commercial matter.
Used for the others.
Malad, my defendant is here.
Commercial matter 44. As per the prayer made by the counsel for the when the next date is fixed.
No, it's running in the list, Malad. Even today it is listed.
By the counsel for the plaintiff, the interim order is extended till 22nd of August 2025 or until further order, whichever is earlier. Let the matter remain in the list.
Great.
Yes.
Yes, Your Lordship, for item number 14, I would like to mention to record a death of defendant number 3 Roman 2 and nothing to oppose
You are appearing for whom?
for the defendant. For petitioners.
Food for partition. One of the defendants have expired. The death we recorded and the name be deleted. Heirs are already
expired.
Heirs are already on record.
Only name is to be deleted.
Only
have
name
you
is-
filed an application?
Yes.
Fine.
That's the paper.
You have an application?
Yes. 14. We have filed a supplementary affidavit application. This is a supplementary affidavit, my lord. We have shown the manner of recording of it. Supplementary affidavit. Supplementary affidavit, my lord. The manner in which the amendment would be carried out.
Only name of the defendant number 3.
3 Roman 2.
3 Roman
2.
Who died? Indrajit?
Yes.
3 Roman 2 is not here. कौन से? Print kind.
Only, my lord, I've shown it here, my lord, in the.
ठीक है supplementary dependent on cost list का cost item है how many plaintiffs?
Plaintiffs are many. Roman 2. That will manage to find a page cost title page 7.
3
I will kindly take out the supplementary. That's the amended final.
एक खोलेगा ये हमारा कौन who died
3 Roman 2. That my lord will see when
3 only 3
Three-
Priya Datta
Yes, she has
Priya Datta died
Yes, she died, my lord. Substitution has been carried out. One of the sons has expired.
Priya Datta died
Yes.
when
The 3rd of April, 2022, 23.
and thereafter amendment was made
Yes.
no in the cause that's why you want to see इसका कहाँ
Amendment
amendment हुआ
was
है
made, my lord.
इसका deletion नहीं हुआ है Priya Datta
That's plaintiff has not done.
by which order Priya Datta name was struck down
Kindly see my application 1.
by which order the name of Priya Datta was struck
Substitution has been effected.
no that's why you see the original plaint Priya Datta is still on record
Plaintiff has not carried out the amendment.
who
Plaintiffs. Plaintiffs have not carried out. Order
but
has
where is the order if order that the department could have been carried out the
then the department.
come on the next day check
So-
check
Well, that order is there, my lord. I can produce.
come with the order
My lord, we kindly give a direction. I will give the order, my lord, to the officers, my lord, within 5 minutes. My lord will give a direction. If the amendment has not been carried out in person to the order, let the department.
let me see the order first
I will bring that.